People against Martin Paul Stewart, 25F244536.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Mr. Stewart. Judge, I appreciate you accommodating me this morning by Zoom.
No problem. So this can be a plea of 5 over, right?
That's correct, Judge.
And you're authorized to enter this plea, and he understands that's 1 point, right?
It is, Judge, and I have had an opportunity to go over that with Mr. Stewart.
Okay. To the charge of 1 to 5 over, responsible or not responsible on his behalf.
Responsible, Judge.
Okay, I'll accept the plea. I'll tell you what, 135, he's pleading his charge, so I'll give him a week to pay until October 9th, okay?
Appreciate it, Judge. Thank you.
You have a great day and go Tigers, right?
Go Tigers. Go green. Take care, Judge.
See ya. Terry Allen Shandern Jr., 25R514282. Name? Your name?
Terry.
Terry what?
Terry Shandon.
Okay. You want to go to a hearing on this?
Oh, yes. That's what we discussed.
Okay. We'll set an informal hearing. What do you have for me, Lisa?
On the BC.
No. Stay right there. So I'm going to set it for an informal.
October 9th at 10 o'clock.
Okay, October 9th at 10 o'clock, and you can go down the hall and get your notice. Any questions?
Nope.
Okay, you go right down the end of the hall. We'll give you a paper notice. Good luck. No, that's in the lockup. You don't want to go in there. The end of the hall. Terry Monique Alice, 25F244664, A and B. Your name?
Terry Owens.
All right, so you're charged with malicious destruction of property, and you also have a second charge of carrying a concealed weapon while under the influence. That's a civil infraction, but a hefty fine. You have the right to an attorney. Would you like an attorney to represent you?
Yes.
Okay, you go out in the hall. They'll just be patient, and a lawyer will be talking to you momentarily, okay? All right, any questions? And then either way, you're coming back in front of me here, all right? Best of luck. Pitts Bowles, Tony. Pitts Bowles, Tony, Natasha. Pitts Bowles, 25F244599A, B, and C. Your name, ma'am?
Tony Natasha Pittsburgh.
All right, good morning. You're charged with operating while intoxicated, malicious destruction of property, and invalid plate. Do you understand that?
Yes.
You have the right to a lawyer. Would you like a lawyer?
Yes.
Okay, I'll give you a lawyer. You can go out in the hallway and you'll be back in front of me after you speak to your lawyer and the lawyer speaks to the prosecutor, okay? Thank you.
How are you? Oh,
You have a 15 basement. Huh?
don't get me started on that.
15 basement. They could brought us into pension.
What's that?
They could brought us into pension.
I know.
We can do that.
Or, yeah.
You see, smiling today, as always. I didn't mean in for otherwise.
Yes.
Everything good?
Oh, yeah, how are you?
Good. Thanks. Tigers, huh?
I know.
They drive you crazy.
Sometimes we pay them to play.
15 base runs. 15. Stranded.
Ridiculous. Yeah, that's ridiculous.
All right. People against Schrank. E. Michael Corey Schrank, 25R 514-283. How you on there, Mr. Schrank? Your name?
Aiden Michael Corey.
You admitted you should have stopped.
Second.
Okay. You're gonna plead impeding traffic, right?
Yes.
All right. So that's 0 points. It won't go on your record. And then they're going to dismiss this 3-point civil infraction. Do you understand that?
Yes.
To the charge impeding traffic, responsible or not responsible? Do you plead responsible or not responsible? Okay, I'll accept the plea. 150 is your total. You go down the end of the hall, make your payment. You're all set.
Thank you, sir.
Have a good day. Good luck. Well, maybe Florida is going to throw a gem today.
Huh.
Tell you what,
So bad.
about 4 games ago, I can't remember who he was pitching against. He had movement on that ball like I hadn't seen from him all year.
He's always up and down. You never know what you're gonna get.
He's going to pitch good today.
They can't score no runs.
Well, they got a bunch of 240 hitters. How are you going to score runs?
Half their lineup should be in AAA.
It's not like their pitching is overwhelming either.
No.
Or Subos, or 5.
Yeah, how much for that cost?
Nothing else is ready. I'd like, is Ms. Patillo out there somewhere today?
She's an arraignment attorney.
Yeah. I'd like to talk to her when you see her, okay?
Yeah. Anywhere you like, as long as you don't sit up there.
She can take this slot. I'll sit out there.
That's all the responsibility that goes.
You're coming in on this?
Yeah, let me go grab my coat. We got it in custody.
Okay.
You
Okay.
want me to grab that real quick, or?
You have that one too?
I have it in custody that I need to zoom in on.
Okay. Is that ready?
No.
Well, let's do Ms. Lennox first.
All right, everybody.
All right, people against Deborah Ann Lennox, 25F 244-672. Ma'am, can you tell me your name, please?
Deborah Ann Lennox.
Attorney Mike Baldwin, House Counsel P 65417 on behalf of this.
She pled the retail fraud. The agreement was it would be taken under 771.1. She was referred for a pre-sentence report. Have you had a chance to review that report with her, and are there any material additions, corrections, or deletions?
Yes and no.
Okay.
Very briefly, Your Honor, my client has one prior driving related offense about, I believe, 20 years ago. But aside from that, she has no marked criminal conviction history. One of the things that stands out with my client from day one, and now that she's fled, I can say it, is she's she's disgusted with her behavior. She is really being hard on herself. And that's important because it shows that she cares. She cares about herself, about her personal dignity, about her impact on society when we talk about property theft crimes. And I feel that it's going to be a very good candidate for the delayed sentence. She is actually, I think, is being harder on herself than the court could ever be. And I trust that she is remorseful, and I do not expect her to behave this way again. Moreover, I do believe that provision 3 of the recommendation is paramount to ensuring that she have a psychiatric evaluation for mental health considerations to maybe get to the question of why she did this. And leave it to the mental health professionals. I have nothing else to add. I think she'll do well. And I wish her the best.
Anything you would like to say, ma'am?
Well, I don't know if sorry is the word for it. I just, I don't want to go through this again, and I swear to God, I'll never do it again. I would like to look into why I even did something like that. I don't know if it's depression or what it is. Something's not the same with me. I'm willing to do whatever will prove that I won't do it again.
Have you ever gone through mental health treatment? You think you need to see a professional?
I don't know if it's like mental, but I've been going through a lot personally and suffering with, I seem to think some kind of, I don't know if it's depression or what, it's just the way I feel about life has just been different.
So you want me to order you to go through a cycle?
What does that entail? I don't understand.
You can do it on your own if you wish. The judge is asking, would you like the judge to order, the court to order you to do it?
You know, I mean, I don't usually,
What
listen,
is
just let me finish a second. I don't usually leave it to defendants to sentence themselves. Okay? But you're 64, 5 years old. You had the drunk driving that you were convicted of, the impaired in 2002. I read your letter that you sent me. You sound remorseful. Everybody makes mistakes. I'll be happy to order you to undergo psychiatric evaluation if you want me to. Otherwise, I'm not sure it's necessary, but I will do that.
Well, I think I would just wanted the sources for someone for me to be able to talk to.
I think that is a very good point, that if it's court ordered, there are public resources through our
How
government.
about if I just order personal counseling? That's what I'm,
Yeah, sure.
No.
There. If you order, I think we may be able to utilize the public resources that are available through the probation department, because she doesn't, you don't have social security.
call in Jessica real quick. Please.
This is here just started, so I don't have all
The benefits.
Right.
Okay.
Let me leave that until I talk to probation, okay? In the meantime, have I let you finish with everything? I'm sorry. I'm speaking low. There's nobody else in here. I apologize. I'm gonna call probation. I'm prepared to go start your sentence. I want to talk to them about what would be available. And we'll go from there. Is that fair? Do you want to say anything else?
But I'm sorry.
You certainly seem remorseful about the whole thing. Like I said, I read your letter this morning, and I'm gonna go ahead and place you on probation for 6 months. They recommended 6 to 12 under section 771.1. This will be dismissed if you're compliant. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. Your name?
Jessica on behalf of probation.
Do you recommend, they're recommending psychiatric evaluation. I don't know that it's necessary. She doesn't have a lot of resources, it sounds like. She has no insurance. You're not on Medicare yet?
No.
Not yet.
If I ordered personal counseling, is there somebody that's going to pay,
So she can call the 1-800 number, the Detroit Wayne Mental Health Authority, and they may be able to assist her with that, given that she doesn't have insurance.
I'm not going to order it, ma'am. If you want to do it, you do it, okay? You're not to enter 27327 Telegraph, Flat Rock, or any other Dollar Tree store. You're to serve 4 hours of community service. I'm going to give you until November 20th. Pay fines 50, costs 50, 75 victims' rights fee, $50 justice assessment for 2 1/4. I'm not going to charge you attorney fees. You don't have the funds. $60 screening fee for 285. Probation fees are 120 for a total of 405. You pay that. You stay away from Dollar Tree store and any other Dollar Tree store. And you come back on your review hearing date. You do your 4 hours community service. Prosecutor will move to dismiss, and I will dismiss. Do you understand all that? All right. If you violate, your probation could be revoked. Your 771 status revoked. Conviction remain on your record, and you'd be subject to a 90-day jail term. You have 21 days to appeal this. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand?
Yes.
Okay. Do you have some of this money to pay today?
How much is it?
405.
I have cash in it probably.
You pay $200 today.
Then where would I pay the rest? Because I get my social security like in the middle of the month.
Okay. You pay $200 today. You pay $50 monthly starting October the 20th. We'll make it the 25th, okay? Okay, wait a minute. And the 25th of every month thereafter until paid in full. If something happens, you don't have the money, you call the court, we'll go on Zoom, or you can walk in here on or before any due date, 8:30. I'll be more than happy to give you an extension. I don't care how many times we have to do it. Just don't ignore me.
Can we set the date, Your Honor?
Yeah, I'm sorry. Thank you. Lisa, what about you?
March 19th of 26 at 9 o'clock.
March 19th at 9 o'clock, March 19th of 26 at 9 a.m. So you'll go down the hall, you'll pay your 200, you'll get your notice, you'll go over to probation, you'll be instructed, okay?
And they'll explain how to. You just go to the clerk to pay.
I'm going to trust this is never going to happen,
Oh, no.
okay? All right, good enough. Good luck. Thank you. Thanks a lot. Anaya Kenyetta Greer, 25F244382.
Judge, Mr. Cayley sent that back in because she wants an attorney.
Oh,
Well,
Okay.
actually, I was just.
wait a minute. Slow down. Your name, ma'am?
Oh, Anaya Greer.
You want a lawyer now?
No, I believe someone named Lisa. They just transferred me to a breakout room to wait, but I wasn't seeking an attorney at this moment.
That was the prosecutor. I sent her to the prosecutor.
Oh yeah,
Oh.
and then the prosecutor said, "Why are you here? Do you want to speak with an attorney? I'm the prosecutor." And I'm like, I don't know what's going on.
It's up to you. If you want one, I'll give you one. If you want to just talk it out with the prosecutor, that's up to you.
Yeah, I'll just talk it out with the prosecutor.
So you're going to waive your right to a lawyer?
Yes.
All right, we're going to put you in a breakout room and you can speak to Mr. Cayley, okay?
Okay.
Wait 1 second, Lisa, before you transfer it. Why did we? Okay. Yeah, I said okay. All right, good enough. Just be patient and he'll be in to speak with you momentarily, all right?
Okay. Thank you.
Good luck.
Go ahead and
Julia,
rejoin the breakout room, Ms. Greer.
Julia Jean Mathers. Default judgments entered in favor of the plaintiff. Defendant failed to appear. This is a speeding citation. The defendant was to be here at 9, and it's now 9:24. We gave her 15 minutes. Take default judgment. Sorry. All right, I have nothing else down there, right? All right, we'll recess until we get something else.
Cleveland, on this one, Cleveland's plus one.
A and B.
Michael A. Crockett, 27384, on behalf of the defendant, Your Honor.
Your name, ma'am?
Very always.
So for purposes of arraignment, does she stand mute and waive formal reading?
Yes.
I'll enter a not guilty plea, and now I understand that you pre-tried the case, so I'll take the plea, I'll set the bond, we'll set it for sentence. Fair enough?
Yes, sir.
Ma'am, if you plead guilty to malicious destruction of property, I'll take this under the provisions of MCL 771.1. I'll place you on probation, set terms and conditions, and if you're compliant at the end of that period of time, that I will set between 6 and 12 months pursuant to the stipulated plea agreement, the case will be dismissed as long as you're compliant. You understand that? And did you sign, read, and understand an advice of rights form here this morning?
Yes.
If you plead guilty at any time, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
To the charge malicious destruction of property, how do you plead?
What's your school?
I can't hear you. Were you on Gibraltar Road at or near 24953 Mayfair in the city of Flat Rock on September 5 of 25 at 6:11 in the morning?
Yes.
And what happened that makes you guilty of this? Malicious destruction.
Yes, busting out car windows. Busting out car windows down.
Did you know the individuals whose cars you were breaking the windows on?
Yes. Pittsburgh's boyfriend.
Ma'am, you got to keep your voice up.
That was Tony Pittsburgh's boyfriend.
And so you accompanied her and you assisted and you busted out some windows yourself?
Yes.
With what? Are you on probation? Are you on probation? Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
And accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted to malicious destruction of property. You were drinking alcohol that day, correct?
Unfortunately, sir, yes.
All right. Let me give you $1,000. I'm accepting the plea, referring you for a screening. You've been drinking, so there's going to be a screening and assessment done.
Okay.
I am going to set a bond of $1,000 personal. You don't have to post any money, no contact with the victims in this case. Denolius Buchanan, and also Jewel Buchanan. You cannot have any contact with prosecution witnesses except through your lawyer. You're not to leave the state without the consent of the court. You're not to violate any law. You must appear in court as directed. You're not to enter or go near 24953 Mayfair. Do you understand that in the city of Flat Rock? Also, I'm going to go ahead pursuant to the agreement and dismiss the civil infraction charge on motion of the prosecutor of the CCW charge. So that will be dismissed. Screening and assessment is ordered. I'm going to give you a date momentarily to come back for sentencing.
October 16th at 8:30.
Okay, ma'am, October 16th at 8:30. So you can go down the hall. You're going to get your paper notice. And you understand this is contingent on you paying restitution, correct?
Yes.
You're going to have to do that. October 16th, 8:30. Go down the hall, ma'am. They're going to give you a copy of the bond sheet. They're going to give you a new notice, and then you're going to walk across the hall to probation where you will fill out a questionnaire and be interviewed. Do you understand that?
Yes.
You got warrants out. You might as well start taking care of those.
Okay.
Where do you work at?
I work at the Michigan Veterans Home at Small.
Lisa, I don't know. Oh, she has been printed. I see it now. Okay. Anything else, Mr. Carmen?
No, sir. Thank you very much.
Thank you. Good luck to you, and we'll see you back here for sentencing. Anaya Kenyatta Greer, 25F 244-382. Ma'am, your name?
Anaya Greer.
Is this yours, Mr. Baldwin?
No, I have Morales. He's
Oh, you waived your right to a lawyer. I'm sorry. So you met with the prosecutor. You're going to plead guilty to the charge of disorderly person, public intoxication. Is that true?
Yes.
That is a misdemeanor punishable by up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
I'm sorry, could you repeat that?
It's punishable. These are just the maximums, up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes.
And did you sign, or I'm sorry, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You do have the right to a trial by court or jury. You have the right to question their witnesses in the trial. You have the right to remain silent at a trial. You have the right to bring in your own witnesses and to use the subpoena powers of the court to bring in those witnesses for a trial. Do you understand all that?
Yes.
If you plead guilty, you're waiving your right to a jury trial. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. And we will not have a trial of any kind. Do you understand that?
Yes.
I'm going to ask you again. You told me before you wish to waive your right to a lawyer. Do you still wish to waive your right to a lawyer?
Yes.
For the charge disorderly conduct, public intoxication, how do you plead?
Guilty.
On July 26 of 25, were you at 28526 Valley Creek Drive, apartment 505 in the city of Flat Rock, County of Woodland?
That's the incorrect address, but yeah, it's
What was the correct address?
25652 Valley Creek Drive, apartment 505.
25652.
Yes.
Let me check something here, please.
Okay.
All right, tell me what you were doing at 25652.
That was my aunt's house and she had my child over there and I was just heavily intoxicated, just knocking at the door, causing a disturbance, and I believe the neighbors just called the cops.
Were you kicking and banging and screaming at the door?
I was screaming, but I was just knocking really hard. I wasn't kicking or anything like that.
This is at 4:27 in the morning?
Yes.
How much did you had to drink?
Probably a little bit too much. I just overcame like postpartum and had a kid, so I didn't
Just
really
tell me
know.
how much you drank, man.
I'm not even, I'm
What
not,
were you drinking?
there's something called like green tea shots. I was just drinking those with.
You got more kinds of alcohol out there now than I've ever heard of. Green tea shots, you're telling me?
Yeah, it's just like a bunch of different things mixed together.
You have no reason to dispute their claim that you were highly intoxicated. Is that true or false?
True.
Anybody force you to plead guilty?
No.
Again, you're not on probation or parole?
No.
I'll accept the plea. I find the plea has been made voluntarily and understandingly and is an accurate plea. The plea is accepted. We're setting the sentence for the 16th again, Lisa?
Yes, October 16th at 8:30.
Okay, ma'am. So you're going to be here October 16th at 8:30. Do you understand that?
Yes.
I need you to show up here to fill out a questionnaire and be interviewed by the probation department.
Okay.
Any reason you can't come here today?
Yeah, I don't have a vehicle or my child's car seat, so I'll just.
When can you come here?
I'm sorry?
When can you come here?
The days that I don't have my child are Saturday up until Wednesday. So anytime, like Monday to Tuesday, I could come.
You have to come in here Monday, okay?
Okay.
For screening and assessment. Okay?
All righty.
John, tell probation I told them that so they can
Okay.
just know it. All right? Bond is continued. Any other questions?
So that's this Monday, the 6th, or is this, or,
Yes, ma'am.
okay, perfect. Thank you.
See you then. Edward Dante Morales. Shoof OP 1384098. 21F235822.
Attorney Mike Baldwin on both cases, for Mr. Morales, who is in custody on.
Mr. Morales, your name? You have to unmute there, sir.
Get the deputy.
I got it. Okay.
Your name?
The host. Am I unmuted now?
I need your full name.
Edward Dante Morales, Your Honor.
All right, you're going to plead guilty, this says, to the charge of resisting obstructing an officer on file 5822 on the basis that you gave a false name. True?
Yes, Your Honor.
That is a
Yes, sir.
misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, Your Honor.
Again, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to trial by court or jury. You have the right at a trial to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. And if you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. You understand that?
Yes, Your Honor.
All right. To the charge, resisting obstructing an officer, how do you plead?
I plead guilty, Your Honor.
I can't hear you, sir.
I gave my false name because at the time, Your Honor,
Sir,
I plead guilty, Your Honor.
listen to me. Do you plead guilty or not guilty?
I pled not guilty, Your Honor. I mean, no, I'm sorry. I pled guilty, Your Honor. I can't, it's kind of hard to,
I'm going to ask you again. To the charge of resisting obstructing an officer, how do you plead?
guilty, Your Honor.
Were you in Flat Rock at 26813 Telegraph on May 21 of 21?
Yes, Your Honor.
Did you give the police a name other than your own name of Edward Dante Morales?
Yes, Your Honor.
And did you give them a different date of birth?
Yes, Your Honor.
Are you on probation or parole?
Right now, I'm on parole, Your Honor, but I'm almost off.
Were you on parole on May 21 of
At that
21?
time, yes, I was, Your Honor.
You
Yes.
understand by pleading guilty to this charge, this would be deemed a violation of that probation or parole? It could
I've
be
already
revoked. Listen to me, please.
Yes,
It
Your
could
Honor.
be revoked and you could be incarcerated as a result of this plea and conviction. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Plea is accepted. Now, we have a sentencing.
No report.
I know. What is he in custody at?
Judge, I'm looking at the register of actions. It looks like he got picked up. I think he was arraigned back in May of 21 on the initial seal stolen property. And I think, I don't know how he got picked up, but I'm looking at the register of actions on the.
I know he's got these two. He's got 10,000, 10% on each one. I just want to know if he's got other holes.
I didn't inquire as to stolen.
Can you tell me, sir, are you in custody just on these two?
No, Your Honor, I got a charge that happened in August of 2022 that they just pulled it up just now. So
Listen to what I'm asking you.
He's trying to develop credit, and that's where we've had some confusion.
Develop credit.
Time credit in being in.
I didn't ask you that.
No, that's not what I'm saying, Your Honor. I said I'm right now in custody for a charge that happened in August of 2022. Right now,
What
it hasn't
city?
even been adjudicated. There's been it hasn't been a preliminary examination yet.
Oh,
So,
all right.
and I was given a PR bond for this charge right here. And
Which
And I was-
charge? Which
the charge
charge?
I'm in here for right, but I'm not the charge with you, but for the charge for which on this one here, which is a felony, I was given a PR bond.
All right, so you're just
Together.
awaiting sentencing.
He hasn't
For
been
your case, I am,
adjudicated on the
Your
felony.
I got it.
And I think I saw PR in that one of those register of actions, but maybe that was historical. And then it compounded because he wasn't showing. He was arraigned on September 30th of
Boy, you are really going out of your way to be unhappy here. You know that? Was there a police report in this file?
There was.
I'm talking about in the one for the concealing stolen property. You didn't,
I didn't see a report in the file for that. That's a 2020.
I know.
I didn't see a report. And you're just for edification, it was a sentencing today, so I didn't delve in too deep as to the facts of the case.
Well, I get it. I'd like to be able to sentence him, but I don't.
You don't have a screening and assessment.
I don't have a pre-sentence report. He didn't show up for that. The case been going on for 4 years. Yes, sir.
Your Honor, if I may, I know that when the case occurred, I was incarcerated. I got arrested, got incarcerated. I did time at the Wayne County Jail. I remember being released from there. I did like 4 months or more in there. My parole, that's why there's no parole hold on me for that charge right now. Because that I've done time for the parole and for, I had a piece of paper. When I left the county jail, they gave me a piece of paper.
Slow down.
Okay.
You got a 4,010% bond that I set. I released you, I set a bond of 5,010% in December of 20. You were in custody for 5 days. You came back in front of me. I gave you a PR bond. On April 28 of 21, I set a 4,010% bond when you had a warrant out and came in front of me. 7 days later, I gave you a PR bond. And then you just didn't bother showing up.
I think Your Honor, it's not that. Please, I know it's so hard to believe, but please understand, it's not disrespect to this court. That's not what this is about. I know I was locked up for a long time because the girl that was with me when I got arrested.
Not on this case.
No, on this case right here, I got the time because she picked me up and I got out of jail with the piece of paper about with this case from Wayne County Jail.
You were in custody for 5 or 6 days from December 11th to the 16th of 20. You were in custody on April 28th when I set a bond 4,010% until May the 5th. You've been in custody since Judge Kirsten set the bond of 10,010% the other day,
September 30th.
September 30. So I'm not saying you don't have some credit for time served.
And that's what I explained that he does.
I
He says that he had,
understand.
hold on, Morales, hold on.
So,
He says he had a judgment of sentence adjudicating the case on the concealed. I checked the register.
There is none.
No, it's the register, it's blank.
You have gotten yourself in all kinds of trouble because you don't show up.
No, I'm not disputing that.
You what?
I said, I'm not disputing what you just said. I'm not disputing Your Honor.
You should have never, ever had to serve this kind of time on this case, although I don't know much about you because you didn't bother showing up for your pre-sentence report. And if I let you go, you know what's going to happen?
I'm going to work.
You're not showing up again.
Your Honor, that's not, I don't believe that, but Your Honor, I've been working at Home Depot. I've been working at Smokers Depot on Liberty, Michigan. I can give you the phone number to my boss, and I've been working at Hammy's Pizzeria, 2 places for the past 3 years. I haven't missed 1 day in 3 years, and I haven't had one police contact, not a civil infraction, nothing to do with law enforcement in 3 years, Your Honor. To me, that's fairly good for a guy like me that has a record like I do. I don't have not one police contact, Your Honor, in 3 years.
I'm just pulling out your record here. Let me take a good look at your record.
In over 3 years, I haven't had nothing, Your Honor.
Right, but you've been a criminal for 35 years.
Thank you, Your Honor. That's why I'm saying it's pretty good for a guy like me that's had a record like I did, and I've done good for the past 3 years. All I do, I don't drink, I don't use drugs. All I do is I work. Every day I get up, I go to work. That's what I look forward to.
All right, okay, settle down.
Well, I just miss it. I just like it's a good thing, Your Honor. People like me you don't experience that in your life.
I'm having a hard time understanding you. Just slow down and keep your voice up. Will you please do that for me?
Yes, Your Honor.
And you got quite a history here.
I understand. I know, Your Honor.
And nobody's going to think that you were a choir boy. You know what I'm saying?
Absolutely.
All right. So just let's get past this. If I knew that they recovered the property, that'd be a different thing.
They did, Your Honor. They got the property. It was in the car when I got arrested, Your Honor. It was just a lawnmower. That's on God's word. That's all it was. It was a lawnmower and they got the property. I had originalized you, Your Honor. They recovered it, they gave it back to the
Settle
people.
down. Settle down.
Thank you, Your Honor.
Yeah.
Let me take a look at this. So you've spent some time in jail here because you did not bother showing up is the problem. But stop. I'm telling you to stop. Just don't interrupt me again. You got a warrant out of Dearborn, by the way, that you've had since 2021. See right on your fines and costs. I can't find that stuff now. No objection, fines, costs. Is that what he said? No objection, finding costs, sentence to run concurrent.
With the existing injury, correct. So whatever jail credit he has, it sounds like he might have 3 small chunks.
Thank you. I got it. I need to talk to you before you leave about something completely unrelated to this, okay?
Yes, sir.
Hmm. 14. Well, he's right. He hasn't been in a lot of trouble lately. All right, Mr. Baldwin, let's do an immediate sentencing. I can kind of read between the lines here. They caught him with the lawnmower. He says they recovered it. They didn't leave it in the trunk if they knew it was stolen property. So I can believe that. What do you want to tell me before I sentence?
I'm asking that the court sentence my client to both cases to a time served with jail credit to run concurrent. My client has already given a brief background history, recent history of what he is doing with his life. Apparently, he is within the last 2 years has been a lot of unproductive.
I know, but the problem is he's almost, what are you, 60? Looks like you're going to be 61 here shortly, right?
Yes, Your Honor.
Aren't you getting tired of doing this?
No, that's why I haven't done nothing wrong in 3 years.
All right, good. Anything else you want to tell me?
Well, whatever you do, I thank you for your time, and I'm sorry that I cost this court time, Your Honor. I really am.
Sorry, did he what?
I apologize for the time I cost this court.
Don't worry about my time. That's what I
And to
do.
take something from somebody, Your Honor, I appreciate things a lot more when I buy it.
All right, good enough, good enough. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment. 4 1/4 or 17 days on both cases, credit 17. We'll close those cases out, Lisa. Send something over and have them released in terms of these cases, if you would, please. Thank you very much. Have a good day, sir. Good luck.
Thank you, Judge.
You're welcome.
Thank you.
So-
Attorney Baldwin.
Jeremy Dwayne Shaw. This is from yesterday. This is 24W8344431. Lisa, he didn't show up. They didn't bring him in front of me on Zoom again yesterday, right?
The sentencing.
Yeah.
I think isn't there a note in there that he was released? Didn't I write a note? If I'm thinking of the right guy.
I don't see anything. Well, this is September 6th. You wrote, Pearl Monroe County defendant released mailed notice to home address. Then I wrote on September 6th, 17, reschedule. The defendant's still in custody because you'd written now in custody at Wayne County Jail, new writ to jail. And I don't think they put him. So if you did, I don't see it.
What's his first name?
Jeremy, Jeremy, Dwayne Shaw, SHAW.
Yeah, he's not in custody at Wayne County anymore.
And we sent it to his home address, right?
Yes. He was getting
Yeah.
bounced around a lot, so I don't know.
I got it. I understand. We're gonna issue a bench warrant, forfeit the bond on this. 7,500, 10% will set on this file, okay, for his failure to appear for sentence yesterday. Thanks. Tony, you have another one?
I was gonna ask if you guys have anything else for me.
Are we almost, this is a very light docket today. Where is, Mr. Baldwin? Didn't we have?
He's dealing with the other half of that co-defendant. And then he's got to speak to the person along him.
And that's it.
So.
Hey, Don.
Thanks.
Cool.
Thank you very much.
We still have a
Is that-
10:30 with Mr. Boulahanis.
Okay, do we have Ms. Patillo out there? Is she in here today, Lisa?
No, I don't believe so.
Somebody wrote on my list that she was in a 227, the arraignment attorney. Can you check on that?
Oh, yeah, she's the arraignment attorney today.
Yeah. 227.
I'll try her again. I tried her before, but. So,
Front desk price.
hey, Vince, do you see Ms. Patillo out there, the arraignment attorney today? She's supposed to be at extension 227.
I think was that the arraignment attorney that just left? Mr. Keel? Okay, we haven't seen her, Judge, but you want us to track her down?
She's here, I'm told. Yeah, would you please, and ask her to come talk to me?
You got it, sir.
Thank you.
All right, bye.
I'm a 525. No cause in here, right? Johnson? Jesselyn Mackenzie Johnson, 24B145-866A. Good morning.
Morning, Judge. Yeah, the CEO on behalf of Ms. Johnson, state just looking for the court.
Jocelyn Johnson.
What happened here? She got show caused and didn't show up, and then now she paid her fines, right?
Yeah, she paid her fines, and I think another issue, Judge, was the community service. She completed that.
She provide us with proof of that, ma'am?
She showed me proof on her phone as the letter that she sent to probation. She completed the community service at a place called Opportunity Center. And
Who's your probation officer? Well, you weren't on probation. I just ordered 2 days community service. Who were you dealing with?
And the probation office, I never really talked to anybody. She just gave me the information to fax my stuff over. But I never really sat down with the office.
All right. What'd she show you on her phone?
so she showed me proof of a letter that came from a place called Opportunity Center. And they stated that she.
Did they say she didn't do her community? Lisa, I don't even see a show cause in here. Do you?
Yes, there's a show cause in there. I saw it. I think it's like 2 or 3 down, 2 or 3 pages down.
Yeah, I see it.
Thank you for calling. Elizabeth Lodge.
Beth? Hey, can you come in here? I got a arraignment on a Jesselyn Johnson, Johnsson. You issued a show cause. It was non-probation case, but I ordered 2 days community service. Perfect. Thank you. All right, let me just get the probation director in here. She was the one that issued the show cause. It was issued back on March the 7th of this year. And it was for fair to pay fines and cost balance owing at the time of 5/25. Why did she not show up? Your client?
So I didn't know if there was an issue with notices, going out.
The old post office through, where were you living? Where do you live now?
I have 216 River, the same location.
Well, they didn't send them to Novi. Come on. Why didn't you show up? I hate that.
I'm sorry.
Well, why didn't you show up?
I honestly did not, I was not aware I was.
When you start with I honestly, and I have a feeling you're going to tell me something that's not honest, that's going to agitate me. Ms. Wilds, your name?
Elizabeth Wells, probationer.
So she paid her money. Her lawyer just told me she's got proof of community service on the phone.
I have it here, Your Honor. She provided it after the show cause arraignment was issued. I do have proof that she did her hours with MCOP, which is the opportunity program down in Monroe, and doing the 16 hours.
You're 26.
Yeah.
You got to have. Where do you work?
Puff cannabis.
At where?
Puff cannabis, it's a dispensary.
All right, listen, here's what I'm doing. I'm going to go ahead and I'm going to close the case. She's paid her money. You've got the proof. The defendant did community service, paid fines, costs. You got to be a little more attentive, young lady. If you got any warrants, I'd strongly suggest you go take care of those, okay?
Yeah.
Good luck. Thanks. Thank you very much. Have a good day. Thank you. People against Kimbler. Mary Jo Kimbler. 25F244542. Mr. Boulahanis, good morning. Your name? Good morning.
Good morning, Your Honor. Greg Boulahanis on behalf of Mary Jo Kimbler.
Ms. Kimbler, nice and loud for me, ma'am. Your name?
Mary Jo Kimbler.
So you pre-tried this, and by the way, I need to talk to you about something unrelated to this when we're done, okay? Mr. Boulahanis?
Yes.
All right, so she's going to plead guilty to operating while impaired. The OWI will be dismissed. There's agreed upon cost of recovery of $225. Ms. Kimbler, if you plead guilty to operating while impaired, the possible penalties are up to $300 fines, 93 days jail, 360 hours community service. Court costs are all those 4 points, license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that? Do you understand that?
Yes, sir.
Okay, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. At a trial, you have the right to remain silent, right to question their witnesses, right to bring in your own, right to use subpoena powers of the court to bring in those witnesses. If you choose to remain silent, that silence would not be held against you. If you plead guilty, you're giving up all those rights. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving the presumption of innocence, and we will not have a trial of any kind. Do you understand that?
Yes, sir.
The charge operating while impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on South Wesley near Gibraltar Road in Flat Rock, August 6th of 25 at 9:36 p.m.?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, sir. A couple of
Nice and loud, ma'am. Nice and loud for me, please.
Couple of vodka and bloody tomato juice. Bloody Marys, a couple of Bloody Marys.
Okay. And what else did you drink?
That was all, sir.
Were you at a bar or did you hand pour those or somebody else?
I hand poured them at the hair salon.
You work at a hair salon?
No, sir, I was getting my hair done.
I never quite heard of that kind of thing before. Anyway, so you hand poured Bloody Marys at the salon while getting your hair cut.
Yes, sir.
All right. And was your ability to operate the motor vehicle impaired because of your alcohol consumption?
Yes, sir.
Why were you pulled over by the police, ma'am?
Didn't have my lights on.
All right.
Lights, Your Honor.
All right. And ultimately, Ultimately, she was arrested, transported to the police station, underwent a blood draw, correct?
Yes, Your Honor.
And you stipulate that the reading was accurate at 0.129 on the blood draw, I believe it was?
Yes, Your Honor.
Ma'am, are you on probation or parole?
No, sir.
Anybody in the world force you to plead guilty?
No, sir.
All right, I'll accept your plea to impaired driving. Dismiss the OWI. Is this a first offense and only offense?
It's first and only offense, Your Honor, and my client's 69 years old and she has nothing, no priors, nothing.
I can see that. All right, ma'am, you have to come over here and be screened and assessed, okay? You're gonna have to come over here today and fill out a questionnaire and be interviewed. If Mr. Bulahanis, if you want to call probation at extension 245, again, 6710201, 734-671-0201, extension 245, they can try to make it more convenient. We'll set a sentencing date, and the sentencing date, they'll prepare a report and recommendation. You'll have the opportunity to review it with your lawyer. That will be on October the
16th at 8:30.
Good for you, Mr. Bulahanis?
Your Honor, is there any possibility I'm gonna be back October 15th in front of you on a hearing? Can we just?
Yeah,
do
I don't
October
need,
15th?
that's fine. We can do that October 15th. You can come a little earlier than the hearing schedule. When do we set that for? 11?
11. Can we do it at 10:30 on the 15th?
Perfect. October 15th at 10:30. Now, Mr. Bulahanis, I was sitting in my office today. You and Mr. Urich were in here to discuss the motion. And I
Yeah.
see this Logan Davis pad. And I came to the conclusion, I didn't look at it. I just came to at first I thought it was Judge Kirsten's writing, but it can't be. It didn't look like it. Anyway, I think you left your pad here.
Okay,
So-
I'll come by and pick it up, Your Honor.
Okay. I
I'm
sure
sorry.
didn't want us to be looking through it, and you might have some other documents there that were yours. I don't know if they were you're highlighting. If you were highlighting reports, I have a tendency to do that. And I know I did that in conjunction with reviewing that motion. But I
Yeah,
just wanted you to know, in case there was anything confidential, I told my recorder to put it in like one of those big yellow envelopes for you with your name on
yeah,
it.
I certainly appreciate Your Honor. I'll be by either later on today or tomorrow to pick that up. I apologize.
No, there's no reason to apologize. No worries. Okay. All right.
Okay.
Thanks a lot, ma'am. Good luck to you. We'll see you in a couple of weeks. But you got to come over here the next day. He'll call and find out when it's convenient for you to be interviewed. All right.
Thank you, sir.
Good
Thank you
luck.
very
Thanks.
much.
Thanks a lot.
Have a great day.
You too. Thank you. All right. And if I need a couple other documents to put in that.
Yeah, that's fine. Do you want to do the no shows, Judge?
Yeah, we can do those. Let's go in a second when both.
Zero 70. We're on 25 CR 0053, a pretrial conference. Your attorney is present in the room now. What does the Commonwealth have to say?
It's a felony plea.
Okay. Motion has been made that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person we just identified in 25 CR 0053?
Yes, sir.
Is your judgment impaired today in any way?
No.
Have you had plenty of time to discuss this matter with your attorney and review the evidence? And are you fully informed about the case? You and satisfied with his representation?
Yes.
Have you viewed the evidence the Commonwealth has against you?
Yes.
You believe that you understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you understand these rights. You have a right not to testify against yourself. No one can make you say anything. A right to speedy trial by jury. Right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand by entering a guilty plea that you give up those rights.
Yes, sir.
Okay. I may consider the range of the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will wait a sentence investigation for it to be done by probation and parole. In the event that I decide to give you a harsher penalty and you have agreed to, you have a right to withdraw your plea and go to trial. Do you understand that?
Yes.
Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to trafficking in a controlled substance first degree meth, the defendant shall receive a sentence of 3 years, serve 60 days in home incarceration, probated for 5 years. Probation.
Incarceration.
Yes, it serves 60 days home incarceration.
Home incarceration.
Yes,
Okay.
sorry. Probated for 5 years. Probation is to be supervised. The defendant shall be allowed work release, attend church, and doctor appointments while on home incarceration. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
So what you agree to?
Your Honor, the only thing that she would ask is that during her period.
I'm not asking what you ask. I'm asking what you agreed to.
Yeah, she picks up her children from school and she just wants to know if it'd be okay for her to continue.
There's no problem with that. Yeah, that's. Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
Doing so of your own free will?
Yes.
You know your constitutional rights explained to us. It's still your desire to give up those rights, enter a guilty plea, allow the court to fix your punishment and arrange permitted by law.
Yes, sir.
You understand that after entering this plea, any future convictions will be enhanced from the persistent felony offender law. Is that your signature on there?
Yes, sir.
Accept the agreement order pre-sentence investigation report to be done and schedule sentencing for November the October the 23rd. October the 23rd. Okay, you need to meet with the probation and parole officer over there.
Thank you.
Yeah. Richard Ferguson.
He's out of custody. We got him in CS.
Carolyn Hardison.
She's about I don't see she made bones.
Commonwealth versus Carolyn Hardison, 24 CR 0080. You're here for the purpose of arraignment. Ms. Hardison, were you born in 1988? Last 4 digits, social security number 3232.
Yes.
You're here on 24 CR 0080. Counsel, would you enter your name to the record?
Your Honor, Luke Lawless for the defendant.
Okay. Somebody have a copy of the indictment?
Yeah.
Counsel, you acknowledge the identity of your client
I do, Your Honor.
and receipt of the indictment,
Yes, Your Honor.
waive formal reading and arraignment, enter plea of not guilty,
Yes, Your Honor. Please not
reserving
guilty.
all pretrial motions. Mr. Bailiff, and that over there. What's the negotiation date?
October 17th at 9 a.m.
Okay, you be here with your attorney on October 17th at 9 a.m. for negotiation, and the next court date you'll be here is on October 23rd. Both of them are conditions of your bond, okay?
Yes, sir.
I'm signing a reciprocal discovery order that requires the Commonwealth to provide you with the information they have so you can help prepare for your defense, okay? No objections, you're continuing on the same bond.
Thanks, sir.
Okay,
Thank you, Your Honor.
yeah. Billy Huddleston. Commonwealth versus Billy Huddleston. 25 CR 0025. Are you Billy Huddleston? You were born in 1962. Last 4 digits, social security number 3418. You're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report? Then the probation law, is it essentially correct? Is there any changes? On a plea of guilty possession of controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. The probation is to be supervised. What are the court costs in this case? $190. Say you need some time to pay the $190. Okay, I'll let you pay it at $30 a month. The first payment starts 30 days from today. Okay. You'll need to meet with probation and parole officer. Okay. Sitting right over there. James Craig. Did I say the name? Creedy, James Creedy. James Creedy here.
I don't believe so, Your Honor. I believe he has an active warrant.
You want to put him in NCIC?
Yes.
Make sure there's no bond on that for FTA. Deborah Polson. Probable person Deborah Polson, 25 CR 0050. Are you Deborah Polson? Born in 1976. Last four digits, social security number 9887. What does the Commonwealth have to say at this? Okay. A motion has been tendered that says you wish to enter a plea today. Is that correct? Are you currently on the influence of drugs or alcohol? Plea freely and voluntarily given. Are you the same person that we just identified in 25 CR 0050? Have you discussed this matter with your attorney? Are you satisfied with this advice? Is your judgment impaired today in any way? You believe you've been fully informed about your case? You understand that you do not have to enter a guilty plea. You have certain rights in the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. Megan, get a chance, not right now, dial on my phone. Okay. You have certain rights, and I need to go over them. Well, you have a right not to testify against yourself. No one can make you say anything. Right to speed trial, but jury right to be represented by counsel at your jury trial. The right to confront proxy and all witnesses called testify against you. Right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Understand that by entering a guilty plea, that you give up all those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply to range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await pre-sentence investigation report, probation, parole. In the event I decide to give you a more harsh sentence than you have agreed to, you have a right to withdraw your plea and go to trial. You understand that? Ms. Coordinator, so is the Commonwealth's recommendation in this case?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 2 years, probated for 4 years, supervised. The defendant shall enter and complete the Cumberland Specialty Program. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is attained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding of the recommendation? Are you pleading guilty because you haven't committed the acts charged in the indictment? You doing so your own free will? Knowing your constitutional rights to explain still your desire to give up those rights and allow the court to fix your punishment in the range permitted by law. Is that correct? You understand by entering this guilty plea, any future conviction can be enhanced to the persistent felony offense. You understand that? That's your signature on the docket. On the agreement there. I will accept the plea and order you to see the probation and parole officer over there. Come back here on October the 23rd for sentencing, okay? Andre Staten.
Your Honor, if I can talk a little bit with Mr. Staten, I apologize. I did not get a copy of the PSI backing, and that's my error.
Andre, she's going to take you back in the room there, go over that with you. Let's go off the record just for a second.
Yes.
New York, Kansas State. Born in 2004. Is that correct? What year were you born?
1983.
1983. Well, you just aged 20 years right there. I was looking at one right below that. This is 25 CR 0041 for a pretrial conference. Last four digits, social security number 2643.
Yes.
What do you have on this?
I spoke to Mr. Russell about this the other day, and he said she wanted a trial date. I went back yesterday afternoon and reviewed the tape again. She's a co-defendant with Andre State. And I just don't believe the Commonwealth had enough evidence to proceed against her as a co-defendant on this because the tape is so hard to hear. So I'm moving to dismiss this case.
Yeah, do you have any objection to that? Well, that's the right answer. Okay, well, you put it down as dismissed then. Hey, you need to be careful from here on out. You understand what I mean? They used to say living at the foot of the cross. That's what you need to do. Okay, okay, thank you. Cody Stinson.
Your Honor, I would like, if we need to, I can approach about his medical condition. But I have been in contact with.
I'm aware of his medical condition somewhat.
And I've been in contact with one of the doctors that's treating him. And he is undergoing therapy or treatment right now. And they would know in 60 days if he's going to be responsive or not. So I would ask that this be continued for 60 days.
No objection to that.
Hey, I'd ask to be continued with the caveat that if some miraculous recovery happened, he's released, that
Yes.
Probate, that we'd be notified of that, and he'd be picked up.
They told me they would notify my office, but you never know. So
Just make sure that that's included in the order that we send to them. Okay, whether or not we can enforce it or not, who knows?
Right.
Okay, we'll put it on for the December 15th. December 15th.
They have another case that I'm already would take that case up.
Okay, I need to bring Mr. Escalona up with interpreters ready. December.
Good morning, Your Honor.
Good morning. How are you? Can you turn your camera on, please?
Your Honor, I cannot. I don't know what happened to my camera, but it's not working. I've been on Zoom all morning and it's not been cooperating. I reset my device, I restarted it, and it's still not working.
Okay, well, you raise your right hand. I'll just take your word for it. You solemnly
Yes,
swear.
Your Honor.
Solemnly swear or affirm that you are qualified to be an interpreter in the courts of the Commonwealth of Kentucky. You've been accepted as interpreter for, and you truly translate all matters that come before the court. Is that correct?
Yes, I do, Your Honor.
Good morning, Judge. Dennis Burke from Mr. Escalona.
Yeah.
Buenos días, señor juez. Denise Parker representando al señor Escalona.
Were you Dixon Diaz Escalona?
Usted es el señor Díaz Escalona.
Sí.
You were born in 1997?
Naciste en el año 1997.
Sí. Last 40, Social Security number 2951.
2951 es los cuatro últimos dígitos de tu seguridad social.
We're on 25 CR 0026.
Estamos aquí con el caso número 25 CR 0026.
For a pretrial conference and motion to revoke bond.
Estamos aquí para una audiencia previa y para una moción para retirarle la fianza.
Mr. Stockton, what do you have here?
Well, we may need to have some filings with the clerk. We've got a plea, a felony plea on 25 CR 26. Then we've done an information indictment. We need a number on a possession of meth case. Has it been filed?
25 CR 61. I don't have paperwork.
Okay, I think.
25 CR what?
61.
00061.
Parece que tenemos una declaración pendiente para el caso que acaba en 26 y luego estamos pendientes de una cantidad de metanfetamina para el caso que acaba en 16.
You have the plea agreement?
I do, Judge.
Just hold it there and I'll
Yes,
ask
sir.
him that way. He'll identify his signature. I'll just go down to.
Time failed to appear. Kevin William Taiji, 25F 244 665. Then failed to appear. We're going to issue a show cause on that. That's a retail fraud. against Kevin, and also he has 25F244773. He didn't show on that either, Mr. Taji didn't, so we're gonna issue a show cause on that. Rakeem Deshaun Gadsden, 25F244729. Defendant failed to appear for show cause. He also failed to previously appear for arraignment and pretrial. Warrant to issue on this, bond to be forfeited. 3,010% will be the new bond. 3,010% will be the new bond.
I couldn't get him to sign his advice of rights because he was in the. Here.
Do we have the other file, Tabitha?
It's done both.
Yeah. All right. Tony Pitts Bulls. 25F244599 A, B, and C.
Thank you, Judge. Good morning. For the record, House Counsel Attorney Mike Sullivan, PC 5117 on behalf of my client, Ms. Pittsford. Miss, can you just please state your full legal name for the record?
Tony Pittsburgh.
Judge, for purposes of arraignment, on the two misdemeanors, my client stands me with formal reading the general information.
All right, so we have an OWI as I previously. We also have an MDOP and we have a valid registration. And so two misdemeanors, one civil infraction. Looks like she has a prior alcohol-related conviction back in 2016. Let me just check out this citation. You live still on College Street, ma'am?
Yes.
Okay. I'm going to give you a $1,000 personal bond. You cannot leave, excuse me. You cannot leave the state without the consent of the court. Cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You do have to attend AA/NA or any 12-step recovery program twice a week. We're going to give you a form. Every time you go, you have to have the form signed, and every time you come to court, you have to bring the form with you. Also, no contact whatsoever with the victims in this case. So you cannot write, see, phone, text, email, or communicate with either. It appears to be Denolius.
Yes.
You shouldn't acknowledge anything here. Denolius Buchanan and or Jewel Buchanan. Do you understand that, ma'am?
Yes.
And also, Also, you're not to enter or go near that address. I think the co-defendant said it was a little bit different, that it was 25627 or something. So you're not to enter the premises at two, maybe I'm wrong.
No, that was another case.
Yeah, you're right. Thank you. Thank you. Thank you.
That was grandma's.
You're not to go near 24953 Mayfair in the city of Flat Rock, okay? So we'll give you a new court date. If you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one. And I'll give you a new date, and that will be on
October 16th at 10:15.
at 10:15.
Judge, let me just make sure if I'm here. Yeah, I'm here, Judge.
Okay. And I do want to still speak with you before you leave. Okay, Mr. Baldwin? Pam, do you have any questions?
No.
Okay, I wish you well. Go down the hall, get your paper notice, fill out your petition for court appointed. Thank you. Joseph Adam Broski, 219F231964.
Again, the record, House Counsel, if anyone calling for Mr. Boston.
Sir, your name?
Joseph Roscoe.
He was arraigned the other day. I set a bond because he'd ignored us for 6 years. He's going to plead guilty to no ops. They're going to dismiss the suspect. True?
Yes.
Is that what you want to do?
Yes.
If you plead guilty, the possible penalties are up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty at any time, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
For the charge, no valid operator's license on person, how do you plead? Reoperating a motor vehicle in the city of Flat Rock, County of Wayne on November 9 of 19 at 2:10 in the morning on Gibraltar near Cahill.
I believe so.
Did you have a valid operator's license on your person?
No.
Sorry?
No.
Are you on probation or parole?
Yes.
Were you on probation or parole in November of 19? No. Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No. I'm
going to accept your plea to no ops, dismiss the suspend. He's homeless. He's not working, right?
Oh, right. I don't know. Yes.
He has an expired license as of September of this year. So we're hoping to keep that license.
You've been in custody since what day? The 29th? What day was he taken into custody?
7.
Why would you do this? Why would you do this? This is crazy. Look,
This was never just.
seriously, listen to me. You got to get your life in order. Did you graduate?
Yes.
Why aren't you working?
I got fired and
Right. Remind me. Why'd you get fired?
just turned activity and stuff. Like
Probably not showing up, right?
here and there. Yes.
He's been in custody since what day did you say? Saturday was the 27th.
I think he has 6.
You don't have any children or anything, right?
No.
Do you want to say anything?
No.
100 fines, 50 costs, 75 victims' rights, $50 justice assessment, 275 or 6 days, credit 6. Please get your life in order. You're 25. You got 65 years ahead of you. But you can't be homeless, not working, and avoiding courts. Good luck. You'll be released if you have no other holds. Thank you. There's no reason for you to be in jail. None. Mike, you got a second?
Oh, absolutely. For you, I got a minute.
involuntarily, and you've admitted to absconding for probation, which by definition is intentionally failing to report for a period of not less than 60 days. So let me catch up on my paperwork here. All right. Mr. Lane, the recommendation, as I'm sure you're aware, is that you are to be released to work camp to complete 5 work camp days, extend your probation 6 months from today's date with no additional oversight fees, and contact probation once released from jail. Ms. Hill, are you here with us? Yeah, I see you now. Was there a specific, was it unclear to me whether or not you're recommending jail up front and then release to work camp, or how you anticipated that to be accomplished?
I did. I meant to do jail up front.
How many days were you recommending?
Let's do 5 days since it's his first offense.
So you want him to go to 5 days jail and be released after that to do additional 5 days of work camp?
Yes, Your Honor.
Your Honor, I would have pled guilty if I would have known that was part of it. Nothing was said about that.
Yep, you're absolutely right. So now you know. What do you want to do?
I want to revoke my plea and get a lawyer.
All right, Mr. Lane, we're going to allow you to do that. But you were arraigned on this in September. It's been a couple of weeks already and you haven't gotten your own attorney. I'm not going to make that allowance forever. So I'm going to reset this for a couple of weeks from now. I expect you to have your attorney by then. Do you understand, sir?
Yes.
All right, and then we'll proceed from there with your attorney. Do we have a date we could use next?
We could use the 17th. It's a Friday in the morning.
All right, Mr. Lane, do you have any schedule conflicts with October 17th at 9 a.m.?
No, that'll work.
All right, we will send out a notice to you, but you're going to need to give that to your attorney once you hire that attorney, and don't waste any time because it's really only about 2 weeks from now, a little over 2 weeks.
Okay.
You have any other questions?
No, no thanks.
All right, we'll see you on the 17th at 9 a.m.
All right, thank you.
Deputy Rock. The judge already did a default judgment for that formal hearing. So you're good to go.
Thank you, Ms. Brucker. All right, the next matter is the state of Michigan versus Daniel Brown, file 25-43650-SM, set for a status conference. Actually, I think it's set for a probation hearing. Do we have Mr. Brown with us?
I don't see Daniel Brown.
Your Honor, this is a second failure to appear. I'd be requesting a bench warrant.
So ordered. Next matter is the state of Michigan versus Elizabeth Nobliski, file 25-43793-FY. I do see Ms. Nobliski is with us. This is a probation hearing. Received a number of emails between the probation officer and Ms. Nobliski. Ms. Nobliski, the allegation against you is that you failed to report for the month of September. You failed to complete an assessment, highway safety class, community service hours, and pay your fines and costs. Plus, the probation department has provided me with a number of emails in which your language to the probation officer is atrocious. September the 15th, looks like September the 17th, September the 23rd, and September the 23rd. The recommendation is that you serve 5 days in jail. You understand the allegations made against you?
Yes, Your Honor.
You understand the recommendation that's been made?
Yes, Your Honor.
You wish to have an attorney represent you in this?
I do.
Are you working?
Not at this time. Not today.
Well, all of your correspondence to the probation department says that you've been working 7 days a week, 12 hours a day. What
I got
happened
it
to
off
that?
I got it off for today.
Well, the question really wasn't, are you off work today? The question is, are you working so that you have funds with which to hire your own attorney?
Yes, but not to hire my own. I'm paying for my mom's rehab.
If you're working, how much are you making?
I'm making enough to pay for my mom's rehab.
Ms. Nobliski, I'm not going to play this game with you. How much are you making?
$1,000 a week.
If you're working 7 hours a day, 12 hours, 7 days a week, 12 hours a day, you're not making $1,000 a week.
It depends on the miles. It depends on the overtime. It's anywhere from 1,000 to 2,000.
So why don't you tell me what it is that your contract says?
Contract for what?
Your work. How much are you supposed to be paid?
18 an hour and then 26 an hour after overtime.
18 an hour at 2,000 some hours a year is about $36,000. You're not going to qualify for a court-appointed attorney because you're not indigent. That's all I'm trying to determine. All right. So I'm not going to appoint an attorney for you. If you want to retain your own, I'd be happy to allow you some time to do that. Is that what you want to do?
Yes.
All right. Right now you have certain rights. I'm going to tell you what those rights are so that you can be aware of them. I'm not going to require you to do anything today other than to simply listen to what the rights are, and then we're going to give you a chance to hire your own attorney. You have the right to have a hearing in front of me as the judge. You do not have the right to have a jury trial. At the hearing, you'd have the right to see, hear, and question the witnesses against you. You'd have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. At the hearing, you could testify or you could remain silent, and that silence could not be used against you. At the hearing, you'd also have the right to be presumed innocent until proven guilty by a preponderance of the evidence. You'd also have the right to appeal if you didn't believe that the hearing went correctly or was illegal in some manner. Do you understand those rights?
Yes, I do, Your Honor.
Do you have any questions about those rights?
I do not, Your Honor.
All right.
In the meantime, does probation go as normal?
It does.
Okay. Thank you.
Let me just say this to you, however. If you are going to use language as contained in these emails towards my probation officer, I am not going to be happy. You understand me?
Yes, I understand.
So any communication that you have with the probation office from here on forward had better be strictly professional. Do you understand what I mean by that?
Yes, I understand, Your Honor.
Because I'm not going to put up with this kind of foolishness anywhere, anyhow, any amount of time. Do you understand that?
Yes, I understand, Your Honor.
Simply not called for. All right, we're going to postpone today's hearing. Do we have a time where we can put this in a couple of weeks?
Yeah, we have room on the 17th as well in the morning.
All right, we're going to adjourn this to October the 17th. Are you able to be available that day, ma'am?
I would be available, but I would need more time for a lawyer.
How much time do you think that you're going to need?
At least a month.
You got a date in the month?
We can do November 6th.
November the 6th?
That works.
That's a Thursday, 9 a.m. Once you get an attorney, please notify the probation office of who that attorney is and what their address is so that we can send them the information that you've already received. I want to make sure that they get all of it so that they can be prepared for that hearing on the 6th of November. Do you have any questions for me, ma'am?
I do not.
All of your same probation orders still apply. You must report and do all of the things that are in your probation order. Do you understand that?
I do.
All right, I'll see you on November the 6th. Thank you. All right, the next case has two files. Excuse me. State of Michigan versus Bonnie Blair, file 25-43393-SM. And then we also have State of Michigan versus Bonnie Blair, file 25-43754-SM. First file is set for probation violation hearing. The second is set for status conference.
Third file. 4044.
There it is. Looks like we also have a third file. 25-44044FY set for a status review. I do see Ms. Blair is here. Mr. Dick, and these are your cases as well, is that correct?
Yes, Your Honor. James Dick on behalf of Ms. Blair for all three files. At this time, Your Honor, we do not have a resolution to these matters. However, I am asking for a brief adjournment and asking that all files follow. The felony case is newly authorized. I believe she was recently arraigned on that.
September 19th, yes.
Yes, okay. So at this time, we would just ask that the case be adjourned so that we can obtain the video discovery for the latest file. And we are seeking to resolve all three of these matters roughly at the same time. So perhaps, I believe that Mr. Fortier was going to request the video this morning. I did speak with him briefly about it. So we would ask for approximately 3 weeks, I think. Should be sufficient.
We have room on the 23rd.
We don't on the 23rd. So her felony case is scheduled for a prelim next week.
We better waive the 21-day rule as well. Part of it.
We can do the 30th though.
Would be October 30th be sufficient, Mr. Dick?
I believe so, yes, Your Honor.
All right. It'll be October 30th at 9 a.m.
I'm ready for the afternoon document.
I'm sorry, it looks like it's going to be at the 1:30 docket. That's still going to be sufficient, Mr. Dick?
Yes, Your Honor.
All right. Ms. Blair, I need to advise you that by moving things to October the 30th, it would be a violation of your right to have the preliminary examination within 21 days. However, you have the right, if you wish, to waive or move that 21-day rule back so that you have sufficient time to negotiate with you and your attorney to negotiate and to obtain the discovery that your attorney is asking for with the video. Your attorney has asked me to do that. Is that what you want to do?
Yes, Your Honor.
All right. Has anybody threatened you in any way or promised you anything in order to get you to waive this 21-day rule?
No, they haven't, Your Honor.
All right, thank you very much. We'll do that then. I'll simply indicate you still have the right to have a preliminary examination if you wish. We're just postponing that down the road a little bit in order to accomplish these things that your attorney has said. So I will make notes in each of these files that we are adjourning this until October the 30th at 1:30. Ms. Blair, I want you to keep in close contact with your attorney because at that hearing on the 30th, I'm going to want to have a decision made as to how this case is to proceed as to all three of these files, if at all possible. I don't want to keep postponing things indefinitely. You understand?
Yes, I do.
All right. That's all for today then. Thank you very much.
Thank you.
Thank you, Your Honor.
(25-43875-SD) set for a status conference.
Good morning, Your Honor. David Delaney, on behalf of the defendant Richie, who is present via Zoom.
Thank you, Mr. Delaney. Good to see you again. All right, we were set for a status conference. Mr. Delaney, do we have a resolution of this matter?
We do. I would request the court sanction a plea agreement between my client and the prosecutor's office.
Go ahead and state that.
He currently has a charge of OWI, second notice offense, possession of a firearm under the influence, and open intox in the vehicle. The plea offer is he would plead to an OWI as a first offense possession of the firearm under the influence at sentencing, the prosecution would dismiss OWI second and the open intox.
That's correct, Your Honor.
I would note further, it appears the statute mandates forfeiture of the weapon. I think that's the case, and if the court agrees, then I don't have any discretion there, nor does the court or the prosecutor.
I do believe that to be the fact. All right.
I can provide the factual basis unless it's the court's practice to do that.
I'd be happy to allow you to ask the questions once we get to that, Mr. Delaney. That's fine with me. All right. Mr. Ritchie, you've heard what the lawyers have said. Is that what you want to do?
Yes, sir.
All right. Right now, I'm going to tell you what your rights are, and you'd be giving up your trial rights. So I want you to make an informed decision about that. So listen carefully. If you want to enter this agreement, you'd be giving up all of the rights that you'd have in a trial. That includes the right to have your attorney represent you at trial, the right to have a trial by a judge or a jury, the right to see, hear, and question all the witnesses at trial, the right to testify yourself or to remain silent and not have that silence used against you, the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You'd be giving up the right to be presumed innocent until proven guilty beyond a reasonable doubt and to have that burden of proof remain with the prosecutor at all times. And finally, you'd be giving up your right to automatically appeal, because if you enter a plea, you're limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
You understand that if you enter a plea today, you'd be losing, other than your right to an attorney, you'd be losing all of those rights?
Yes, sir.
All right. I'm going to have Mr. Delaney ask you some questions, but I need to have you sworn in first. So if you raise your right hand, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
All right. Has anybody promised you anything or threatened you in any way in order to get you to enter this plea today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right, Mr. Delaney, if you'd ask the factual basis questions, please.
Yes. Mr. Ritchie, on June 22nd of 2025, were you driving a vehicle in Otsego County?
Yes, sir.
Were you on a public road?
Yes, sir.
Had you been consuming alcohol?
Yes, sir.
Do you agree that you were operating that vehicle above the legal limit allowed by law?
Yes, sir.
You were stopped by law enforcement, is that correct?
Yes, sir.
And they then took either breath or blood test from you, is that correct?
Yes, sir.
And those results showed you to be over the legal limit allowed by law?
Yes, sir.
At the time that you were operating that vehicle, did you have a handgun that was in the vehicle?
Yes, sir.
All right, that was a lawful handgun. In other words, you have a CPL for that weapon?
Yes, sir.
But it was in the vehicle, and so you possessed that weapon while under the influence. Is that correct?
Yes, sir.
I understand from the report there were no incidents regarding the weapon. There were no issues with law enforcement. It was just taken by them?
Yes.
Okay. I have no further questions. Thank you.
All right, Ms. Brooker, any other factual basis questions?
No, Your Honor.
All right. Do either attorney know of any promises, threats, or inducements not stated on the record today?
No, Your Honor.
No.
Do both counsel believe that I've complied with the plea taking court rule?
Yes, Your Honor.
You have.
All right. Mr. Ritchie, I do find that you've given me a proper factual basis. You've admitted to operating while intoxicated on a public highway with a blood alcohol level above the legal limit, and also to possessing a firearm while under the influence within Otsego County on or about June 22nd of 2025. And you've done so, I believe, knowingly, intelligently, and voluntarily based on your answers to my questions. So I will accept your plea to drunk driving first offense and to possession of a firearm while under the influence, which is count 2. The original count, second offense notice in count 1, and the count 3 open container in a vehicle will be dismissed via nollie by the prosecution. Mr. Ritchie, there is a requirement that a substance abuse assessment be completed prior to sentencing. So I'm going to direct you to obtain that, and Mr. Delaney can assist you with where to go as to how to get that. We're going to adjourn this out approximately 30 to 40 days in order to get that assessment done so that I can have that available at the time of sentencing, and then we'll have you back. I'm required to tell you that in the meantime, any actions you take between now and the time of sentencing can be used by me at the time of sentencing to enhance your sentence, including if you act badly enough, a decision by me to not accept the plea offer that was made in this particular case. I don't anticipate that having to occur because I anticipate you'll do your best to be on your best behavior. But I just want you to be aware of that information so that you can conduct yourself accordingly. Do you have any questions about that, sir?
No, Your Honor.
All right, let me see if we can get a date as to when sentencing will be.
Do November 13th in the morning.
Is everyone available on November the 13th, which is a Thursday at 9 a.m.?
Let me just check my schedule. I did want to note he's already made contact with an assessment company in Gaylord, and that's in progress.
Excellent.
Okay. That date is available for me, November 13th, Thursday.
Yes.
Okay.
You say 9 a.m.?
Yes.
So November 13th at 9 a.m. I'll see everybody then. All right, that's all for today. Thank you.
Thank you.
Thank you.
Next matter is the state of Michigan versus Ted Shatroff, file 25-43711-SD, set for sentencing. I do see Mr. Shatroff is with us.
Yes, sir.
As your attorney with us, Mr. Shatroff?
He just texted me a few minutes ago, said that he's in another Zoom right now and would be back shortly.
All right, we'll just pass your case and we'll come back once he's here.
Absolutely, sir. Thank you.
Next matter is the state of Michigan versus Akeem Stedholm, file 24-43239-SD, set for a status conference.
Your Honor,
Go ahead.
Attorney James Dick is in a breakout room with one of his clients.
Okay, we'll pass that matter as well.
Larry Browns are unrepresented. Stack.
Okay. Next matter is State of Michigan versus Destiny Twitchell, file 25-43751-SD, set for sentencing today. Do you see Ms. Twitchell is with us? Mr. Brown, this is your matter, I believe.
It is, Your Honor.
All right, this is the date and time set for sentencing. Mr. Brown, I've got a notice that your client may need to be fingerprinted. So if you could assist her in getting to the sheriff's department after today's proceedings and having that taken care of, I'd appreciate that.
Okay, Your Honor.
I have received a Catholic Human Services Substance Use Assessment Report signed by Charles Heidema, looks like on September the 2nd. Mr. Brown, have you received a copy of that?
I have.
Ms. Brooker, have you received a copy of that?
I don't see one in my file. I don't see assessments for any of the OWI sentencings we have today, but I don't object to the court going forward.
All right, the recommendation from Mr. Heidema is she appears to have cannabis use disorder mild and alcohol use disorder mild. Recommendation is for outpatient substance use counseling. Counseling to provide insight and education regarding the continued use of substances. He indicates that the client appears to be minimizing alcohol consumption, and the substance use counselor will determine the risk and level of treatment appropriate at the time of intake. Mr. Brown, anything else you wanted to add to that summary of the?
Yes, I would ask the court to accept the recommendations given by the assessment. I did have a conversation with Ms. Twitchell. She's currently 29 years old. She does have 2 children at home. Excuse me. She was not driving in any kind of a poor manner or anything like that. So there wasn't any kind of an accident. That's not to justify it, but she did state that she was at a friend's house. She had some drinks, a couple of shots, she said, and left very shortly thereafter. It was about a 12-mile drive home. And I don't think she really realized that and this is maybe where the counseling can come in, that alcohol just affects everybody differently, but I don't think she realized it was going to affect her the way it did in that quickly. So I would agree that perhaps counseling may be the best thing for her family, and also for society in the long run.
All right. Ms., and I'll give you a chance to make any other comments you wish after Ms. Bruker goes again, Mr. Brown. So Ms. Bruker, any other comments that you have?
Yes, in addition to the what's in the assessment, I guess my concern is with this particular case is that she also did this when she had her very young children in the car. I think she was stopped around 2 a.m. or so. So she's drinking, driving with her kids. So I would ask that the court follow the recommendations of the assessment and place her on probation so that she has to do that.
All right. Mr. Brown, anything else that you want to add after hearing what the prosecutor said?
No, Your Honor, I would defer to Ms. Twitchell if she has anything.
All right. Ms.
Yes, sir.
Situation. I misspoke. It is a diversion agreement rather than federal.
Y voy a corregirme porque esto es un acuerdo para un programa alternativo, no para declaración de delito mayor.
A motion's been tendered that says you wish to enter a guilty plea to that today. Is that correct?
Se ha presentado una moción indicando que usted se quiere declarar culpable hoy para dejar el caso resuelto, ¿cierto?
Sí. Are you currently under the influence of drugs or alcohol?
¿Actualmente está usted bajo el efecto del alcohol o de alguna droga?
No. Is this?
Violation of community control, violation, failed to report contact with the Euclid February 28th. You understand that charge?
Yes.
Failed to report contact with McCandless Police Department May 1st. You understand that charge?
Yes.
Left the state of Ohio May 1st without charge.
Yes.
And convicted of theft in Pennsylvania August 18th. You understand that charge?
Yes.
Mr. Fatico?
Good morning, Your Honor. I discussed these matters with Ms. Parker-Atkins. I believe she'd like to waive her probable cause hearing and final hearing, accept responsibility for misconduct in these allegations, and resolve the violations today.
Is that what you want to do?
Yes.
All right. What's your plea to the allegations?
Guilty.
I'll accept your guilty plea and find you guilty. What are you doing?
The Euclid incident, I had a seatbelt ticket. I just didn't pay the ticket. And the Pennsylvania, I was with my friend and her mother. She was going to shop for her daughter's, her younger daughter, a car, and we went into a Gabe store. Her daughter, my friend walked out with a suitcase, and they charged me and all of us at the same time. And no, I didn't report because I was scared. And that's what happened. They ended up giving us community service out there.
Where are you working?
I work at Richmond Heights Rehab Center.
Mr. Fatika?
Your Honor, Ms. Parker Atkins is 29 years old. She's employed as an STNA at the nursing home in Richmond Heights. Her fees and costs are paid in full. She was doing well on probation other than these two incidents. We asked the court consider continuing on community control sanctions.
Well, I didn't have her doing much, right?
No, the main thing was employment, which she's met. And she's, I don't think there's been any issues with drug screens.
Any problems with her?
No, she's reported as scheduled. She hasn't missed a reporting. She has stayed up to date. The issue that we had was not reporting misconduct and leaving without permission in the state of Ohio.
Well, your history indicates 3 thefts as a juvenile. And now 3 thefts and this breaking and entering as an adult. Why do you keep doing this stuff?
The breaking and entering, they gave me that charge because if you look in the case, I was with my friend. She was
Well,
fighting.
that's
It was a
this
fight.
one. That's this one.
Well, I don't know. I wasn't stealing.
Huh?
I wasn't stealing.
All right,
I
let's-
see that I was with, like I said, I was with my friend. And
What about the one in Parma last July?
they gave me receiving stolen property.
Okay, so what happened there?
I did take something.
All right, well, why do you keep getting your, all right, let's assume that you didn't do anything in Pennsylvania. Okay. And you got the breaking and entering here when you were just helping your friend.
Right.
Why do you, if that's all true, okay, why do you keep putting yourself in positions where you keep getting into trouble?
I just got the wrong group of friends.
Okay, well, get a different group of friends.
I know. I have another friend, Jasmine. She came here with me. She's a nurse. This felony is kind of ruining my life. I got kicked out of school because of it.
Okay.
I have 2 kids, and I can't even rent an apartment with this felony on my record.
Okay. Well, you'll have to figure out what to do about that. Okay.
I got a
But,
job.
but if you keep doing stuff like this, it don't get any better. How much do you work?
I work 40 hours a week.
Okay. Go to work. How old are your kids?
My son he'll be 11 on the 9th, and my daughter is 7.
Okay. Why don't you go to work, take care of your kids, and quit hanging around goofballs. That way you'll stay out of trouble. You won't have to come here and listen to people like me. All right, so you're still on community control. Knock off the stupid stuff. Anything else, Mr. Fatika?
No, thank you, Your Honor.
All rise.
The Kentucky and United States Constitution.
Tiene derechos constitucionales según las leyes de este estado y del país.
Before I can accept a guilty plea today, I need to know that you fully understand those rights.
Tengo que asegurarme que usted entiende los derechos que tiene antes de aceptar su declaración.
You have the right not to testify against yourself. No one can make you say anything.
Tiene el derecho a no declarar en contra de usted mismo. Nadie le puede obligar a hablar.
You have a right to speedy trial by jury.
Tiene derecho a un juicio con celebración, con juez o con jurado.
You have the right to be represented by counsel at your jury trial.
Derecho a tener abogado que le represente durante el juicio.
You have a right to confront and cross-examine all witnesses called to testify against you.
Derecho a interrogar y contrainterrogar a los testigos que declaren en su contra.
You have the right to produce evidence.
Derecho a traer pruebas.
To call witnesses in your favor.
Y a traer testigos que declaren a su favor.
To appeal this matter to higher court if you lose.
Derecho a apelar cualquier sentencia a un tribunal superior.
And to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you.
Y derecho a que sea la Fiscalía quien tenga la carga de prueba de demostrar su culpabilidad más allá de cualquier duda razonable.
You understand by entering a guilty plea today, you give all those rights.
Como usted se va a declarar culpable hoy, entiende que no habrá juicio, por lo tanto, renuncia a sus derechos asociados a un juicio. ¿Sí o no?
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law.
Puedo aceptar la recomendación de la Fiscalía, pero también tengo derecho y autoridad de sentenciarlo conforme las pautas que indica la ley.
Prior to accepting any recommendation, I will review the pre-sentence investigation report. Now, this is a pretrial diversion on one of them, but on the other one.
Well, that's since they're being done contemporaneously. I don't know how every court wants to handle it.
Yeah, before I go any further with this seems rather unusual to me. This gentleman was in court here previously.
Yes, what happened was he was charged with having a vehicle with altered VIN number.
Yeah.
When he left court, he was picked up on possession of methamphetamine.
And he had a bad license plate too, didn't he?
I don't know. I'd have to look at that. Yeah, he had a altered registration, no registration plates.
Altered.
Yeah, revoked license. He's going to have to get his act together if he's going to complete his diversion or felony plate.
You know, it just, I don't know the facts of the case other than what I read there. It just seems a little odd to me that we got him on a VIN thing. Was arrested on a VIN thing originally. Then he comes back down here with a vehicle with the altered. Was that a stolen car that he was down here with that had the bad plate on it? He comes down here with a stolen car and meth.
Let me see. I'm looking for the new paperwork on the information and that. Now, all this put together, my understanding was on all the illegal traffic violations was on the first truck when he came down here. What he was indicted on initially. When he left, that's when they got him on the possession of meth. You got the name of
El primer caso que tiene es por haber tenido un vehículo en venta con un número de registro alterado. Y el segundo cargo es por haber estado parado por posesión de metanfetamina.
Here, I found it, Your Honor. On the information indictment, he had no registration plates and an altered registration plate, what he was charged with, and possession of a controlled substance, third degree and first degree.
Whose car was? Let her interpret here. Go ahead.
El primer cargo que tenía era por cosas de tránsito referentes a la matrícula y al número de registro del vehículo. Y el segundo cargo era por la metanfetamina. El juez pregunta de quién era el vehículo.
If I may offer, Judge,
You speak Spanish?
No, sir.
How were you communicating with him back there then?
I have a translation app. He speaks some English, Judge.
Yeah, okay.
I also have a translate app.
Okay.
We're able to communicate.
I didn't know whether you get in here with your phone or not, so go ahead. You can go ahead and speak, defense counsel.
The felony on the information is the possession of the controlled substance. I think the altered plate was just a violation. So the new felony is actually having the controlled substances as a further punitive measure as part of this.
You'll let the interpret.
Yes, sir.
El delito mayor que tiene es solamente por la posesión de metanfetamina. Los cargos que tiene de matrícula y del registro de vehículos son solamente infracciones de tráfico.
As a further punitive measure, if you will, and as part of this negotiated settlement, he is forfeiting both vehicles.
Well, that's almost correct. The first vehicle, the truck that had the altered VIN number in, he's forfeited. The second vehicle, which he was arrested in when he left court, that didn't have registration plates, it had a title to it, and Sheriff Williams released that to the owner.
Okay, I did not realize that, Judge.
Yeah, it was titled correctly, it was registered.
De los dos vehículos que tiene, él va a hacer entrega de los vehículos y el fiscal corrige que el primer vehículo, que era una camioneta, sí que era entrega de ella y el otro lo llevaron a la persona a la cual está registrado el vehículo.
And he has no prior felonies, Judge.
Y no tiene ningún anterior condena de delito mayor.
Wonder who the owner of the vehicle was.
It's not in the police report, I don't know.
¿De quién era el propietario del vehículo?
Look again, make sure I don't need to look at. No, it doesn't say, it doesn't say who long it was.
Have you previously been diverted in the last 5 years?
Caballero, en los últimos 5 años, ¿ha estado usted en el programa alternativo?
No sé qué es eso.
I don't know what that is.
Have you had a pretrial diversion? Have you been in court and entered into a pretrial diversion that you like you're entering into today?
Es decir, en los últimos 5 años, ¿ha tenido usted algún caso en el tribunal y en lugar de condenarlo o multarlo, le han permitido que hiciera unas clases o programa?
You have any felonies in the past 10 years?
¿No tiene condena por ningún delito mayor en los últimos 10 años tampoco?
You understand that if you fully complete the diversion agreement, the charges will be dismissed.
Entiendes que si cumples todos los términos y condiciones del programa, tus cargos serán retirados y perdonados.
You understand if you do not successfully complete the diversion program, you'll be brought back in front of this court and your pretrial diversion will be revoked and a scheduled sentencing hearing will take place.
Y de lo contrario, si no completa usted el programa con éxito, volverá a estar aquí frente a mí y se le condenará a un plazo de tiempo de cárcel.
What is the Commonwealth's recommendation?
Upon a plea of guilty to selling a vehicle with the altered VIN number.
La Fiscalía sugiere que se declare culpable a un cargo único de haber vendido un vehículo con un número de registro alterado.
The defendant shall receive a sentence of 3 years.
3 años de condena.
And upon a plea of guilty to possession of a controlled substance, first degree.
Declararse culpable a estar en posesión de una sustancia controlada.
In case number 25 CR 61.
Que ese es el número de caso que acaba en 61.
The defendant shall receive a sentence of 3 years.
También una condena de cárcel de 3 años.
The 2 sentences shall run consecutively for a total of 6 years.
En caso de cumplir condena, se cumplirían 3 años más 3, por un total de 6.
He shall serve 45 days.
Tendrá que cumplir tan solo 45 días de cárcel.
The pretrial diversion shall be for a period of 5 years.
Y después tendrá 5 años de plazo en libertad, tiempo durante el cual tiene que hacer el programa alternativo.
The diversion is to be supervised by probation and parole.
y el programa será supervisado por el Departamento de Libertad Condicional.
He shall be released from custody on October 12th, 2025.
Y este día 12 de octubre de este año 2025 será puesto en libertad.
He shall receive credit for time served.
Por lo tanto, se le van a restar los días que ya ha estado en la cárcel a los 45 días y su salida será el 12 de octubre.
The Ford 2012 F-350
La camioneta del 2012 F-350
shall be forfeited to the Cumberland County Sheriff's Department.
será entregada al departamento del sheriff del condado.
He agrees to be assessed by the Social Services Commission.
Y también se someterá a una valoración por parte de servicios sociales.
And shall follow all recommendations.
Y tendrá que seguir todas las recomendaciones de ese departamento.
He shall pay court costs at discretion of the court.
Y tendrá que pagar costas judiciales si su señoría lo considera oportuno.
All drugs and contraband shall be destroyed.
Y cualquier tipo de droga o contrabando que se incautara para este caso será destruido.
Is that your understanding of the Commonwealth's recommendation?
¿Está usted al tanto de la recomendación del condado?
Yeah.
Yes.
Has anyone, including your attorney, offered you any other benefit for entering this plea?
¿Alguna persona le ha intentado convencer de alguna manera o prometido con algo diferente? No.
We are pleading guilty to the acts that you committed in both these charges, the indictment and the information, because you did those acts. Is that correct?
Se está declarando usted culpable de estos dos cargos porque en efecto usted cometió estos dos actos, ¿correcto?
Knowing your constitutional rights have explained to you, is it still your desire to proceed with the plea and allow the court to fix your punishment in the range permitted by law?
Después de considerar todo lo que le he ido explicando, ¿está usted dispuesto a seguir con su declaración de culpable y dejando en mis manos la condena según las pautas de la ley?
Is that
Yes.
your signature on the motion and offer?
¿La firma que está ahí a pie de página es suya? Yes.
Mr. Stockman, what kind, before I accept the agreement diversion, or what kind of background check did y'all do on this?
We did a Kentucky CourtNet search, and we also did an NCIC report. He had some felonies in Jefferson County that have been amended down, and they involve stolen property. So I don't know if he's involved in a car theft ring in Jefferson County. I don't know why he was down here in Burkesville, but he's got 6 years hanging over his head and he's going to be on probation. So he better be living at the cross, because I will file a motion to revoke him, because I don't know what his status is, why he was here and what he's been doing.
Hemos visto que sí que tiene algunos antecedentes en otros condados, pero no sé cuál es su estatus inmigratorio en este momento aquí.
I will accept the agreement and sign the diversion order.
Acepto el acuerdo y firmaré la orden para el programa alternativo.
That's your signature on there, sir, did you say?
Esa firma es la suya, ¿verdad, caballero?
Now, you need to wait till after your interpreter tells you what I say before you answer it, because I know you can understand everything I'm saying.
Espérese a que la intérprete traduzca antes de contestar, porque yo entiendo que usted comprende lo que estoy diciendo.
Okay, you need to meet with the probation parole officer. I don't know how we're going to do this exactly. He's going to be in jail up there for a few more days. Can you see him up there with the interpreter online or something?
Se va a reunir con el agente de libertad condicional en la cárcel porque va a estar unos poquitos días más en la cárcel.
The police said he's supposed to get out on the 12th, which is Sunday. If he can report to my office on the 13th, I can facilitate his transfer back to, I think he lives in Louisville. I'll have to do that.
Okay, you give his attorney the address of the probation parole officer, and you'll be there at 8 o'clock.
8 a.m.
8 a.m. on the 13th, which is the day after you get out, okay?
Caballero, usted saldrá de la cárcel el día 12. El día 13 a las 8 de la mañana tiene que reunirse con su agente de régimen probatorio.
Court cost is $190. You need some time to pay that?
Debe $190 de costas. ¿Y cuánto tiempo necesita para pagarlo?
Judge, if we could get maybe days or something of that nature, 90 days.
Well, I'm
90
only paying
días.
30 days. I'll let him pay it at $50 a month, first payment.
You'll get it paid.
Do it in 30 days. Yeah, I'd say his employer wants to get him paid probably.
Thanks, the judge. He told me his wife's present. She can pay it today if you'd like.
That's good.
Lo tiene que pagar a razón de $50 al día hasta que esté al mes hasta que esté pagado los 190.
Okay, thank you.
Thank you, Judge.
Muchas gracias. Thank you, everybody.
You are released, Madam Interpreter. Thank you. Have you gone over that with Andre Staten yet?
I have your own.
That, you know, bring him out. Commonwealth versus Andre Staten, 25 CR 0042. You Andre Staten. Yes, sir. Born in 1963. Yes, sir. Last 4 digits of Social Security number 4710. Yes, sir. You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report on probation and parole? Is it substantially correct?
Yeah, sure. The only thing that was left off were his children were not reflected on his where it lists all of his family members. They're reflected in the PSI, but not listed out, so he can update that with probation and parole.
Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
For plead guilty to trafficking and controlled substance first degree, defendant shall receive a sentence of 3 years, served 60 days of home incarceration and balance probate, 5 years probation to be supervised. The Commonwealth agreed for home incarceration to begin on September the 3rd, 2025.
And Your Honor, the court had agreed when we entered the plea because of the conditions of Mr. Staten's legs to just let him be under the condition of the court on home incarceration instead of having the ankle monitor attached.
Court costs, what's the court cost?
It's $190.
$190. You need some time to pay that. So pay it first payment 30 days from today, $30 a month. Okay. You need to meet with the probation and otherwise. We already addressed Cody Stinson, correct?
Yes, sir.
Okay. Ashley Stotts. Ashley Stotts. This is a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, Ms. Stotts has a 5-year sentence on false statements to receive benefits. She's paid the restitution in full on that case. Yes, I think it's about a year and a half ago. And this is a motion because she's tested positive again for marijuana on 9/2/25.
Response, Your Honor, Ms. Stotts says it's Delta 8, Delta 9, and Ms. Stotts indicates that what she purchased was purchased over the counter. To simplify things, she has decided just to cease and terminate use of any product whatsoever regarding Delta 8 or Delta 9. And I think it would be appropriate just to put her on unsupervised probation at some point in time. So she's got everything she.
Have you got, I got the report. Where's that report? I guess it's in here, baby. Could you help me find that violation?
We had a problem once before, and she had gone out of state to purchase some items, and she got some sanctions on how long did you stay in jail then?
3 weekends.
Yeah, 3 weekends.
I'll watch the tape of it again.
Got back.
She'll pay it. I want you to. I mean, she's got numerous violations here.
Yeah, it was all.
I don't understand why I haven't revoked her already, you know.
Well, all those looks like we brought it to the court's attention back in 2024. That was when all this came to a head, and that's when you gave her the sanction.
Yeah,
and
I
then
watched that tape though.
Yeah, and then she had an additional violation in this August. So it's been, what, a year ago? Yeah.
And as I say, we don't agree it's a violation because it's over the counter legal in Kentucky.
She says.
That's right. And that's.
She says, I don't know that, you know, she had receipts where she bought it.
You wouldn't have a receipt. No, she has no.
Well, she didn't buy it over the, you know.
She has her original certificate where she's permitted to obtain marijuana legally in the state of Kentucky. She does have that.
And I don't know, I looked at that a while ago.
Well, it appears to me, it doesn't really matter to me whether she can get it illegally or not. And here, Mr. Stockton, here's the way I look at this thing. Just so we all, since this is kind of the first impression, she can buy alcohol illegally too, but she's not supposed to use alcohol when she's on probation. Is that right? Can she use alcohol?
Yeah.
Well, so what's the difference?
May I agree?
When I'm finished, you can. I'll give you your time. So I'm not I just don't want to go down this route from here on out that anybody thinks they've got a certificate where they can legally use marijuana. I don't think there's any difference in that. They can legally use alcohol. They're not supposed to use it. Okay. And if they've got some kind of extenuating circumstances, they can notify the Commonwealth Attorney's Office and we can have a hearing on it. Now you can.
Your Honor, the difference is the prescription. You don't get a prescription for alcohol. You get a valid prescription from the Commonwealth of Kentucky for marijuana. I'm not saying I agree with the way the system is set up, and I realize there's tremendous gray areas in all this right now, but that is the inherent difference is the prescription. Somebody that comes in with a valid prescription, we got to look at it different, and this is going to be an ongoing problem. I know.
Where's your prescription? You have a copy of a prescription with it?
You guys know that? Okay. Yeah, perfect. Here we go.
Have you seen this?
I've got the certificate. Is that what you're referring to? Yeah.
Make a copy of this here. I'm going to pass over this case until October the 23rd, and I'll give you a copy of this.
I've got a copy.
Okay, I want to an investigation done on the validity of that prescription by the Kentucky State Police or probation and parole. See what's going on here. So you'll be back here on October the 23rd.
Thank you.
Give her the original. Will she want her certificate back? Well, thank you. Probation and parole, and you have a copy of that certificate?
I do, Your Honors.
Yeah. I'd like to take it. You provide it to the state police, if you will, okay?
Yes, Your Honor.
Dakota Vince. Are you Dakota Vincent?
Yes.
It's 25 CR 0048. Your year of birth 1991, last four digits social security number 2748. You have a purpose for arraignment. You have an attorney with you. You have a right to remain silent. And information has been returned in this court charging you with possession of controlled substance, meth, first degree. This is 25 CR 0048. And also drug paraphernalia. Do you understand those charges? Mr. Bailiff? Counsel, you acknowledge the identity of your client received in that waive formal reading arraignment, enter a plea of not guilty.
Yes, Your Honor, this is a rocket case, though.
Okay. What kind of, we have a felony plea here?
Pretrial murder.
Motion intended that says you wish to enter guilty plea to that today. Is that correct? Is that correct?
Yes, sir.
Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in these two informations that I just read?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? You believe you've been fully informed about your case? You understand that you do not have to enter a guilty plea. You have certain rights in the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you understand those rights.
I do.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury. You have to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence and call witnesses in your favor. Have process issued to compel or attend to right to appeal this matter at higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a plea of guilty today, you give up all those rights.
Yes, I do.
And I may consider the Commonwealth's recommendation, but I may apply to you bringing to the Senate to provide law. I don't have to accept the recommendation. In the event I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
Have you previously been diverted in the last 5 years?
No, sir.
Had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you complete the diversion program, the charges will be dismissed, pre-trial diverted?
Yes, sir.
You understand if you do not successfully complete the program, you'll be brought back or have a violation be brought back in front of the court, and the court could void your pre-trial diversion, schedule a sentencing hearing. Is that correct?
Yes.
If you do that, you'd be a convicted felon that can be used against you in the future. You understand? What's the Commonwealth's recommendation, Mr. Coordinators?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 2 years, pre-trial diverted for 4 years, supervised. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall receive credit for time served. The defendant shall obtain gainful employment for do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of that's consistent in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agree to?
Yes.
Are you pleading guilty under this information because you did commit the acts charged in the indictment information?
Yes, sir.
Doing so of your own free will.
Yes, sir.
Knowing your constitutional rights, I've explained to the desire to proceed, enter pleading guilty to the charge, allow the court to fix your punishment.
Yes.
That's your signature on the offer.
Your Honor, this is an unsigned copy. I believe the original is already been filed for.
Yeah.
Yes, that's on this part.
I'll accept the agreement, sign the diversion order. You need to meet with probation and parole officer. Court costs are what?
It's $190.
$190. You need some time to pay that.
I can have it tomorrow.
Do what?
I can have it here this afternoon.
Okay, well, I'll give you a week to pay it, okay? Just in case you get stopped. Thank you. Elizabeth Watson.
Thank you. Thank you.
Commonwealth versus Elizabeth Watson, probation revocation. You are Elizabeth Watson.
Yes, sir.
Born in 1970, the last 4 digits, social security number 8925. We're here in 24 CR 0086. Where's your attorney?
Don't have one.
Matt Garman did. What do you have?
Ms. Watson's got a 3-year sentence on possession of a controlled substance. She reported, she was given a urinalysis. She was positive for meth. Based on Officer Garnin's training, he believed that the sample had been altered. She admitted to drinking pickle juice and baking soda to try to dilute the test. And he sent it out for the lab and it came back over 10,000 nanograms per liter for methamphetamine. So she had a very large amount.
The attorney just filed a motion to withdraw and didn't even show up or anything?
Don't think he was retained in the criminal charge. Yes, we retained.
He hadn't been retained for this, okay?
If I may, we only received notification of this on Monday.
Of his withdrawal.
And of this particular case. I do have, if I may add, a report.
You need to not say anything else, you know. You be back here on October the 23rd with council.
That's fine with me. I'm the probation violation warrant issued in this, and I'm not trying to be vindictive in any way, but her test results was so high, I worry about her safety being out until October 23rd, out of custody. This is the second case I've had on withdrawal and drug court.
What we're gonna do is I want, what's the most stringent testing that you can do on her? Her report.
Like in terms of what you're like how.
Well, between now and the 23rd, the Commonwealth is concerned that she'll overdose or get some fentanyl in something and die because of the high content. She's probably gonna, I see a paper there, and when she has counsel, she's gonna probably contest the test or do something like that. I don't know what she's gonna do, but what is the most frequent testing that you can do on her to make sure that she's not taking anything?
Well, Your Honor, I know she's getting ready to present you.
I don't want to know what she's.
I got you. She's in IOP right now currently for her first use. So she's being tested weekly right now as it is.
Well, I'm going to let that be enough. The Commonwealth has done its duty to express some interest in your welfare and that you don't overdose or something like that. So, you know, at some point, Ms. Watson, nobody else can protect you. The Commonwealth can't protect you. I can't protect you. Nobody. I'm going to go ahead and allow you to come back here with counsel prepared to defend this revocation motion on the 23rd. I don't want to read about you in the Cumberland County News or on Facebook, your obituary. You understand what I'm saying?
Yes, sir.
Okay, thank you. Austin White. Austin White. Commonwealth versus Austin White, 25 CR 0045. Are you Austin White?
Sure.
You were born in 1999?
Sure.
Last four digits, social security number 8022.
Thank you.
We're on 25 CR 0045 for pretrial conference. What do we have?
It's a misdemeanor plea.
Judge, now I think that is missing this one in its entirety, and then there's a information to replace it with the new case number.
What are y'all doing in this case?
Also, we're doing a misdemeanor plea, is that right?
Yeah, that was my impression.
Yeah, we understand it's more complicated than that. What's the deal?
No, I didn't know it was like that.
Initially, he was indicted on the 3 counts, 5 counts of the felony and the plea. They told Jessica would be under a new case with just 1 misdemeanor count, and that this case would be dismissed.
Did we get information? Yeah.
What was he charged with?
He was charged with theft of identity, 5 counts. And what happened was the restitution was messed up in that indictment because they said he owed $500 and some dollars. When he only owed about $100 and some dollars. So we were going to do a misdemeanor plea to pay the restitution and do a new case and dismiss the old case.
So the 3 features back here.
Because I couldn't amend the theft of identity down to theft.
That's what it was.
Because part of the problem was he was being charged for tires that were paid for as part of the restitution, which was incorrect.
Thank you. So you use somebody else's debit card to buy?
He worked at a tire shop. He improperly used somebody else's debit card, took about $150. When the officer worked the case, he incorrectly added the amount of the tires that were paid for on there and made it $500 and some dollars. And he was charged with like 5 counts of theft of identity, which was too many because he only used it twice, I think, for $150. And so we agreed to settle the case, 12 months, probated for 2 years, misdemeanor, and make restitution.
Whose card was it?
James Elder from Cumberland County.
Who is that?
I don't know him, and we've had difficulty trying to find him.
Yeah, pretrial diversion.
No, I was just doing a misdemeanor plea, 12 months for 2 years.
A motion has been tendered, says you wish to enter guilty plea today. Is that correct?
Yes, sir.
Well, you don't seem too enthusiastic about it. You don't have to enter a plea if you don't want to.
I did the ethic about the whole situation at all, but I'm here to enter a guilty plea.
Okay. Are you currently under the influence of drugs or alcohol?
Sure.
Is this plea freely and voluntarily given?
Sure.
Are you the same person named in the indictment that we just called? Is your judgment impaired today in any way?
Sure.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Sure.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Oh, yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial, but your right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called testify against you, right to produce evidence, right to call witnesses in your favor, have process issue, appellate or attendance. You have a right to appeal this matter to higher court if you were to lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by you plead guilty today, you give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply range of sentence by the law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will. Prior to accepting a recommendation, I will determine what the sentence will be. I understand this will be a misdemeanor plea, so it won't be necessary to do a pre-sentence investigation. Madam Assistant Commonwealth Attorney, Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to theft by deception less than $500, the defendant shall receive a sentence of 12 months probated for 2 years. Probation is to be supervised. The defendant shall pay restitution in the amount of $150 to James Elder. The defendant shall pay restitution in full at the entry of this plea.
Is that what you agreed to?
Sure. Your Honor, I believe he's already paid restitution, or his employer has paid the restitution to him. I just told him to provide proof.
Yeah, once we verify that, that'll be fine.
Knowing your constitutional rights have explained, is it still your desire to give up those rights and allow the court to fix your punishment within the range permitted by law? Do you understand? Okay, I don't feel exactly right about this one. There's something that I don't understand about it. Where did he purchase the tires? Is he working for a tire company? What's the deal?
Yeah, Mr. White worked for a tire company.
Here in Cumberland County?
I believe it's here, probably 90 tires.
Over Marybone? Yeah. And allegedly he purchased some tires with somebody else's credit card.
Somebody came in and they purchased tires for themselves. The credit card was left. And then the allegation is that Mr. White used the credit card for other purchases.
Well, that makes more sense to me. Okay, I'll accept the agreement and what the court costs and
$223.50.
need some time to pay that.
Oh, yeah, sure.
Okay, well, I'll let you pay first payment of $50 through 30 days from today. He paid $50 every 30 days to get that paid off. You need to make the probation parole officer there. Okay. That is your signature on the agreement there. Okay. Okay, Kenneth Wood. Cromwell versus Kenneth Wood, 20 CR 0040. Hello, are you Kenneth Wood?
Yes, sir.
1960?
Yes.
Last 4 digits social security number are 8992.
Yes.
20 CR 0040, and you are?
Clay Kennedy, Your Honor.
Good. Welcome to Cumberland Circuit Court, Mr. King. What does the Commonwealth have to say?
Your Honor, Mr. Wood has a 3-year sentence for possession of controlled substance. He tested positive for cocaine on August the 20th. My understanding, Ms. Beckley should be on the line, is that he was evaluated by the SSC, placed in treatment. I don't know how that's going. Maybe she can tell us. And then he has another revocation in Shelby County involving a firearm, but I don't know anything about that. Maybe she can tell us.
Hello, Your Honor. I apologize for not being on here earlier. Mr. Woods was supposed to talk to our SSC last Tuesday. They had trouble getting a hold of each other.
Can you turn your camera on? Can you turn your camera on?
Oh, yes, sir. Yes, sir. Hello.
You raise your right hand. You swear that testimony you're about to give us the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Yeah. Ms. Beckley, have you been supervising Mr. Wood?
I have.
And did he have a positive test for cocaine on August the 20th?
He did.
Okay. And what steps did you take?
So we got him in front of the SSC, had him evaluated, and they're looking at doing an outpatient program with him. I know that they had tried to make contact with one another last Tuesday. Last I heard, the SSC had tried to reach him. I'm not sure if they did. I think Mr. Woods' phone was off, and when he turned it back on, he had a voicemail, but he didn't have the phone number to reach our SSC. I don't know if they ever made that contact, if Mr. Woods has been given that information as to where he's to be going.
So he needs to, if he leaves the courtroom today, he needs to contact the SSC and set up his treatment. Is that correct?
Yes.
Okay.
And then his case was just indicted here in Shelby County. I think he has a court date on October the 27th.
That's correct, Judge. It's a new indictment in Shelby County. We're set for arraignment.
What's the charge?
It has to do with the firearm. It is,
I just forgot the exact, Judge. I looked at the gist of it, wasn't attempting to buy a firearm.
it's fraudulent firearm transaction.
That's correct.
I believe he tried to purchase a firearm, not realizing he couldn't do that while he was on diversion.
Okay. So that's what we have. He's got a drug test and he's not set up his treatment like he's supposed to, and a new felony charge.
Yes, sir.
Okay, well, I'm gonna ask you to appear on the 23rd of October, unless you provide the Commonwealth proof that you have successfully enrolled in the treatment program. And also, I will want to report Quincy to be arraigned up in
Judge, that's not until the next week on the 27th. And part of what I was going to ask the court was for some time to get the discovery on that new case.
November 20th.
November 20th?
November 20th is when he shall appear back here.
Okay.
But I want you enrolled in this treatment program. And you give our probation parole officer here your phone number and contact information. So this lady can get in contact with you or give you them. Do you know where to call to set up the treatment?
I've been trying to get.
He has my cell phone number, and also Mr. Woods, I know I gave you October 15th report day, but I'm moving you to the 8th, which is Wednesday. So we will definitely have it all squared away by Wednesday.
You have the number for me then.
Or you need to speak up.
Will I be able to see the evaluation officer? And that's who I've been trying to contact, but I don't have his number. He's supposed to call me back, but he hasn't.
Right.
To set up an outpatient program.
Okay.
That's all.
If you reach out to me, I will make sure that I give you that information. But at the very least, you're going to see me in person next Wednesday, October the 8th. And you and I will definitely have it done in person.
Okay. Is that okay? You gonna do that?
Yes.
Yeah, and you stay away from any firearms.
Oh, I have.
Okay, thank you very much.
So our next day is
November 20th here, and he's got to be at part of his condition of continued fine as he shows up next Wednesday.
Absolutely.
Okay.
Thanks.
And Your Honor, first thing in the morning, because he has difficulty going to the restroom. So I need him to understand to be there first thing in the morning.
8 a.m.
I will be.
Okay, thank you very much.
Thank you.
Thank you.
Okay, is there anybody else here in the court that needs to see? If not, we're going to go to Eastern Kentucky Correctional Complex. Are you on the line?
Yes, sir.
Okay, if you turn your camera on, Commonwealth versus Paul Bricker. Are you Paul Bricker?
Yes, sir.
Born in 1985.
Yes, sir.
Last four digits, social security number 1839. We're here for pretrial conference. What's the Commonwealth have to say?
Your Honor, I've entered an offer in this case, Ms. Costello, and we've discussed this case, and I think she had a problem reaching Mr. Brigham.
So, yes, Your Honor, I called to set up an appointment and they were unfortunately on lockdown. So the records department indicated that we would have an appointment tomorrow morning,
Okay, let's continue this case.
Monday at the latest. So
October the 23rd. She's gonna come see you and you'll be back in front of the court on October 23rd. Okay?
Yes, sir.
Mr. Bricker, I also got an update in your civil case as well. So I'll give you that tomorrow morning. Okay?
Yes, ma'am.
Okay, thank you very much.
Thank you.
Eastern Kentucky Correctional Complex, you're excused. Hardin County Detention Center. Hardin County Detention Center. Are you on there, Hardin County? Okay, will somebody turn the camera off for Eastern Kentucky Correctional Complex, Hardin County Detention Center, Commonwealth of Kentucky versus Wesley Smith, 24 CR 0072. Are you Wesley Smith?
Yes, sir.
Born in 1993.
Yes.
Last four digits of your social security number are 2348. Is that correct?
Yes. Yes.
Probation. What do you have to say, counsel?
Yes, Your Honor. Mr. Smith has been incarcerated for nearly a year now. And as soon as he was able to, after sentencing, was able to enroll in some programs, he immediately did. He's completed MRT.
What was the original charge again?
Traffic control, substance over 2 grams.
What's Commonwealth have to say about it?
He had 2 cases at the time, Your Honor. One of the cases was dismissed as part of the plea. In this case, he got 7 years and 6 months. He sold about over 4 grams of meth on a patrol by. His parole eligibility date is July of 2026. So I assume they must have flopped. That's the reason he filed this motion. I don't know, or if that's when his first parole eligibility date is. So.
Counsel, what do you know about that?
Well, I don't know if he's been flopped before. I know his parole date is in 2026, July 21st. His parole eligibility.
That's probably correct because he's only got 10 months and 7 days. I guess my question would be, where's Mr. Smith going to live? Is he going to have a job? What's his plan for treatment or anything?
You know, what do you say?
And he's willing to do, inpatient, long-term.
I'm sure he'd do anything to get out. The question is, where is he going to live and what's he going to do? He's got a job and he's going to continue to sell drugs. That's the main identification.
Well, I know he wants to get a hold of his substance abuse issue. And Mr. Smith, where is it that you're going to live?
My mother, Tammy Pruitt's house. Yeah.
That's still not telling me anything. What's his plans? If he got a job?
Got a job lined up?
Yes, sir.
Tell us something. I don't want to be like pulling teeth from you here, man. Where you going to live with your mother and now you got a job lined up? Who's it with? What kind of, tell me something.
I got a couple of leads on some jobs. I can go to the logwoods or I can work for my cousin doing concrete. I have a guy in Bowling Green I can work for doing framing houses. Just depends on what kind of treatment I have to do.
Here's what I'm going to take this motion under advisement, and I want you to have your attorney provide the Commonwealth with a pattern of conduct that you're going to do, where you're going to work, what you're going to do, where you're going to live, that sort of thing. And I'll take it under advisement and render a decision before the next rule day. Okay. And the next rule day is October the 23rd. And after council, if you and the Commonwealth can't reach an agreement on this, then we'll have a hearing for you on the 23rd. Okay.
Thank you.
Okay. There's no one else there at Hardin County. Hardin County may be released and you're. Thank you very much. Okay, let's go to the Luther Luckett. Is Luther Luckett on there? Luther Luckett. Are you on there? Luther Luckett, Correctional. Robert Tabor.
Yes.
Can you turn your camera on, please? Are you Robert Tabor?
Yes.
Good morning. This is 25 CR 0055, Commonwealth, Kentucky versus Robert Tabor. Mr. Tabor, you were born in 1987.
Yeah.
Last four digits of your social security number, 3597.
Yes.
You're on a pretrial conference. What does the Commonwealth have to say?
I don't know. Are you ready to do anything on this case?
Well, I just need that additional evidence to go over with you.
That's correct. He's a state prisoner at this time. And
would you speak up a little bit?
Mr. Tabor's already a state prisoner. He's serving quite a bit of time. Mr. Rutherford needs to look at the advocacy center tape. And also it appears that we owe him some more discovery besides that, because I got an email from Ms. Rich. There's been additional disclosures from the victim while she's been in there.
October the 23rd, pre-sentence for October 23rd. You need to have him there on a negotiation day.
Yeah. I would think if, yeah, let's put on the negotiation date.
October 17th.
Yeah.
October 17th for negotiation. Next court date here is October 23rd, and your attorney will come talk to you, Mr. Paper, okay, explain what's going on here, okay?
Okay, because I haven't heard anything from anyone.
Well, let me tell you what, counsel, I don't want to have that response from again. I'm telling your attorney, when you get in contact with you, fully inform you, you got a right to know what's going on, and I'll make sure that happens, okay?
Okay, thank you.
Your Honor, I've already contacted
Well, I
the
don't
facility.
care what you've done up to this point. It hadn't been enough, so you'll have to rectify that, okay?
Thank you.
Thank you. You're excused, Mr. Tabor. Luther Luckett, thank you for your cooperation.
Thank you.
Yeah.
Okay, so that's all?
Barron County Detention Center. Barron County, if you're on there, Barron County Detention Center. Barron County, if somebody see if Barron County's on there? I don't see him. Okay, let's go to Clinton County Correctional Institution. Clinton County, are you on there?
Yes, sir.
Are you Isaac Dalton?
Yes, sir.
Morning, Mr. Dalton. We're here on 21 CR 0034. You born in 1988?
Yes, sir.
Where did this social security on 3833? We're on a probation revocation. What does the Commonwealth have to say?
Your Honor, we have a new violation on domestic violence, assault, fourth, strangulation. It'll be going to Clinton County grand jury, the next grand jury. Also, I have the Officer Wayne Glover here testifying the victim. If we need to have a hearing.
You want a hearing, you'll stipulate.
Your Honor, if possible, where I represent him in the case in Clinton County, could I have more time just to see how that case is resolved?
Is that violation reflected in the indictment?
No, he will probably be indicted on it, but I really don't want to wait. He's got a 10-year sentence. I've got my witnesses here and it's free discovery for him.
Okay, let's call your first witness.
I call Officer Wayne Glover.
Okay. Raise your right hand, please. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth. I do. Take a seat there in the witness stand, lean forward, state your full name with whom you're employed.
Name's Wayne Glover. I'm employed with the Albany Police Department.
Okay, you may inquire.
Officer Glover, did you have an occasion to see Mr. Dalton on August 9th of this year?
I did, yes.
Can you tell the court what happened?
Yes, I was in the dispatch center somewhere around 5 o'clock. And when a call came in from a young lady who I think identified herself as Mr. Dalton's daughter, she advised that her parents were in an argument or in an altercation. I left the dispatch center and headed en route that way. While en route, dispatcher advised me that a young lady had called and said her dad had her mother in a headlock. When I arrived, Miss Dalton, who is Mr. Dalton's wife, was walking northbound from the residence on Dalton Street with Mr. Dalton in close pursuit behind her in a very aggressive and threatening manner. He was yelling, gesturing, etc.
Was he cussing at her, threatening her, or what was he doing?
Appeared to be, yes.
Okay, go ahead.
I exited the vehicle and ordered him to stop. He told me he wouldn't effing dealing with me. I ordered him to stop again. He started to flee. I had to deploy a taser. He continued to resist arrest. Had to deploy pepper spray. I was able
Even after you tased him, you had the
Yes.
pepper spray to get him under control?
Yes.
Okay.
Afterwards, once I got him handcuffed, a neighbor came by and assisted me to get him into the car, get him in the back of the police car.
Okay. Did he appear to be under the influence of any substances?
He did, yes.
Okay. He was charged with alcohol intoxication.
Yes, he smelled strongly of alcoholic beverage.
Okay. And you also charged him with resisting.
Yes.
Was that, did he do anything to try to pull away from you?
Yes, yes, he did.
When you was trying to handcuff him?
Mhm, yes.
Did you do that before or after you deployed the taser?
Afterwards.
Okay. And then did you go after all this and you got in the hospital ultimately, then did you go and try to investigate what had happened?
Yes, I went back and talked to Ms. Dalton. She advised that Isaac had came home drunk. He started an argument. She went to another room in the house, a bedroom, and he followed her. He shoved her against the wall, maybe spit on her. She made it from the bedroom back to the living room. He threw her down on the couch, choked her. She was able to get away and get outside, and that's basically when I came up.
And evidently their minor daughter saw some of this and called the law.
Yes.
I've got no more questions.
I'd like to inquire.
Yeah, I've got just a couple of questions. So Mr. Dalton's wife, did she have any markings or?
She had some faint red marks on her neck and on her arm.
But you didn't see any bruising or?
No, sir.
Did you go to the hospital after that?
Did she?
Yes.
To my knowledge, no.
And that's all the questions I have.
I don't have a greater.
This all should be released.
Yes, sir.
Thank you. You got another witness?
I do have one more, Jessica Dalton. One more. Yeah.
Sheriff here. You raise your right hand, you swear the testimony you're about to give is the truth, no truth, and but
Just Charlotte.
lean toward the red microphone, tell us your name.
Jessica Dalton.
And you may inquire.
Where do you live, Miss Dalton?
Right now at 736 Dalton Street.
Okay. And is that the residence also of Isaac Carr Dalton?
Yes.
And you've heard Detective Officer Glover testify about what happened on August 9th. Can you tell us what happened?
He come home, I was sitting on the couch and I could tell something was wrong. Didn't know at the first. I told our daughter that we needed to leave for a little while and I walked to the bedroom to change my clothes. And he come back there and he started screaming at me. And I made it to the living room. I got pushed into our heater. I was spit on. He got me, I can't remember if he got me down on the couch the first time. He had both his hands around my neck. Our daughter come in at some point. He had me like around this way on this side. He got my ear, my face. It ended up bruising and scabbing over. I made it outside. I got pushed down and once again I was spit on, and our daughter had went up to our family's house and I was trying to get up there to check on her, and I started walking on the road and he was following me, and that's when Officer Glover showed up.
Did your daughter, where did she call the law from?
She called the law. I wasn't sure if it was outside or if she went up to our cousin's house and called it in.
Did she have a cell phone?
Yes.
Okay. And did she see this, what happened in the house?
Yes, sir.
Okay. And how old was she?
13.
Okay. And after this, did you go to the doctor or have you seen that?
No.
Okay.
You want to inquire?
Yeah, I just have just a couple of questions for me, Ms. Dalton. From the beginning of the alleged altercation to when the police were involved, about how much time passed?
I'm not sure, maybe 10 minutes, if that, I don't know. I didn't.
A relatively small amount of time.
A small amount of time, yes, sir.
That's the only question I have, Your Honor.
I don't have any reread.
Okay, you can step down. You have another witness?
No, that's all. No.
You want to call your witnesses?
No.
You want to make an argument?
I mean, the only thing I would say, it seems like this was a frenzy moment, according to the allegations. I'm not sure about, whether Mr. Dalton was under the influence of anything or not, but, I would ask the court to consider treatment as possible.
Yeah, I'm going to give you some treatment. Anybody that get a woman down and choke her and beat her like that, I just can't tolerate that. I'm going to revoke his probation and impose a sentence. Okay, thank you.
Thank you.
Okay, let's go. Is Barron County on the line yet? If not, let's go to the Dare County Detention Center. Right, Barron, okay, let's go to Barron County. Barron County, are you on there? Yeah, there you go. Let's have Bobby Garman, please. Bobby Garman, 25 CR 0051. Are you Bobby Garman?
Yes, sir.
Morning.
Good morning.
It's 25 CR 0051. Mr. Garman, were you born in 2001?
Yes, sir.
Last four digits, social security 1566.
Yes, sir.
We're here for trial conference. What's the Commonwealth have to say?
I believe we agreed to pass this one more time because he has a case in Maytag County and I can't remember. Grayson County.
October 23rd, is that, you pass this case to October 23rd? And need him there on a negotiation day?
17th.
17th for negotiation, 23rd, both of them conditions of bond, okay? Timothy Jackson. Thank you. Are you Timothy Jackson? Good morning. This is 25 CR 0060. Mr. Jackson, were you born in 1984?
Yes, sir.
Last four digits, social security number 9460.
Yes,
You're
sir.
here for the purpose of arraignment. Do you have an attorney? The public defender's office represents you in district court.
Yeah.
What was that answer? Sure.
It was Corey Rutherford, maybe?
Yeah, I'll continue the appointment. Your attorney is here, okay? You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with theft, unlawful taking or disposition, receiving stolen property, persistent felony offender as to receiving property, and persistent felony offender by theft, unlawful taking and disposition. Mr. Bailiff, you present that to counsel. Counsel, you acknowledge the identity of your client received the indictment away form or even arraignment enter plea not guilty, preserving all pretrial motions.
Yes, Your Honor.
The negotiation day on October 17th, next court date's October the 23rd.
Yes, that's fine, Your Honor. Ms. Hill has the majority of the cases, the Monroe County cases, and she's requested that we mediate the case, and I don't have any objections. I don't know if Mr. Rutherford's want to do that here too on the Cumberland County case.
Yeah, I have an objection.
So if we just
Put it out to November then?
yeah, and we can just enter an order.
November the 20th, the cases in Monroe and Cumberland County ordered to be combined for the purpose only of negotiation. We'll determine later whether we consolidate them for judicial economy under this criminal rule. I'm signing a reciprocal discovery order to require the Commonwealth to provide you all the information to prepare your defense. Your attorney will be over and talk to you.
Thank you.
Okay, thank you. That's all we have at Barron County. Thank you for cooperation. We'll go to Adair County.
Can we be excused, Your Honor?
Yeah, thank you so much for cooperation. Carson, do you want to turn your camera off there a little bit? Always good to see you.
Sorry about that, Judge. I just realized I left it on.
That's okay. Commonwealth versus, let's go to Adair County. Adair County Detention Center.
Good morning, Your Honor.
Morning. Commonwealth versus Denzel Burton. Are you Denzel Burton?
Yes, sir.
Morning. This is 22 CR 0058. Mr. Burton, you born in 1971.
Yes.
Last four digits, social security number is 1609. We're here for probation. What's the Commonwealth have to say?
Your Honor, in this case, Mr. Burton has a 10-year sentence on traffic and controlled substance. He has 4 misdemeanors in Allen County that are set for pretrial conference on October the 17th. He has a new indictment on assault second and domestic violence in Allen County that was just returned, I think, yesterday or day before. This case was on last month, and I have it where he was charged with fleeing and evading on the second degree. I've got Officer Marr and Sergeant Del Rio to testify about that. And I think also Officer Marr has got him under investigation for theft of a church. So I'm ready to proceed.
You want to stipulate?
Let's just wrap this up and go ahead and revoke me. I don't want to hear no more of this bullshit. How about that? You two cops, fuck y'all.
Hey, that's enough.
Hold on, sit it
We're
back
done.
down.
The judge wants to speak to you.
Get him and bring him back and sit him down in the chair.
Burton,
You have to.
come back and sit.
Come down and sit down.
I'm good where I'm at.
Miller, can I get you to the conference room, please?
Okay, I want to, I just sentenced him to 6 months in jail for contempt. And 6 months, we'll take a look. We won't revoke him. Just go ahead and take him back in the cell block and get 6 months.
Yes, Your Honor.
Grilled cheese day.
Thank you.
The officers can be excused.
The officers, you can be excused. If you do, we'll call you back again.
Take him out. We're done.
Okay.
Yes. If you want what I had to say.
Alfred Crecilius. Good morning. Are you Alfred Crecilius?
Yes, sir. Good morning.
Morning. This is 25 CR 0052 and 25 CR 0033. Mr. Crecilius, were you born in 1985?
Yes, sir.
Last four digits, social security number 5305.
Yes, sir.
Okay, we're here on a pretrial conference on those two things. What did the Commonwealth have to say?
I think we have a film clear.
Okay, well,
I wasn't able.
Oh, I'm sorry. We just got paperwork done this morning. We just said it for.
October 23rd. I think we got an agreement on the case, but your attorney will be able to go over the papers with you, Mr. Crecilius, okay?
It'll all be good time.
This will all be good time for you that you got
All right.
down there. Okay, thank you very much. Barry Gibson. Barry Gibson, thank you.
Yes, sir.
Good morning. Are you Barry Gibson?
Good morning. Yes, sir.
22 CR 0037. Mr. Gibson, were you born in 1969?
Yes, sir.
Last four digits, social security number 9632.
9632.
We're here for a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, he had 2 misdemeanor charges in July, including violation of EPO and a voyeurism charge of felony. I don't think he's been indicted on that yet. Also, he's got a new case of state police is working involving video and minors. So if he wants to put this off, we can. If not, I can give him a quick hearing date. We don't have that case yet from the state police.
Let's continue the case till October 23rd. Do you have enough time between now and then, or?
I should have. If not, we can have Officer Poole here to testify.
October the 23rd. They've got additional information they're going to provide your attorney to get ready for a hearing. Thank you very much.
Thank you.
James Hurst. Commonwealth versus James Hurst. Are you James?
Yes, sir.
Hurst?
Judge,
This
Judge,
is
that's all I have. May I be excused?
absolutely, it's always good to see you. You're working for Team Kentucky there. Commonwealth versus James Hurst, 22 CR 0013 and 22 CR 0038. You are James Hurst,
Yes, sir.
1970.
Yes, sir.
That's four digits, social security number 2119.
Yes,
What does
sir.
the Commonwealth have to say?
We had Mr. Hurst on back May 18th for revocation. In lieu of revocation, the court granted him opportunity to go to rehab. He stayed in rehab till about 9/11/25. He left treatment. He didn't report to probation and parole. Nobody knew where he was, and he had to get a warrant and have him arrested.
And Your Honor, he had a medical condition. He had
You want a stipulation?
no. I just want to point out, I think he called Mr. Gardner and he wanted to speak with him as soon as he got out because he was just worried about his health.
Bring Mr. Garner around, take testimony. You raise your right hand, officer, testimony about to give us truth, whole truth, nothing but truth.
Yes, sir.
Thank you. We may inquire, Mr. Stockton.
Yeah, I was trying to find my revocation motion. See, got another file. I'm getting another file. Yeah, I mean, when you're ready, here.
think it would.
Let's start on page 3, I think, and that's goes to May the 18th of when he was granted opportunity to go to rehab. Where did he go to?
ARC Crime Recovery Center.
And where was that located? Do you know?
I don't know the actual address of that facility.
Was it Bardstown, St. Catharines?
I don't know the address to that facility.
Okay. Did they report to you that he'd left?
They did.
And when did that occur?
On 9/15/25, officer was notified Mr. Hurst has left treatment without permission or completion of the program.
And did he leave on about 9/11 or what date did he leave?
According to the letter that I received from ARC, he left on 9/11.
Okay. And did he claim that he had permission to leave?
Yes, according to the exit letter from ARC, he said that he had permission from the judge and the prosecutor about the issue, and he was approved to leave.
Okay. Had you talked to him prior to him leaving?
No,
Did you give him permission?
no.
After he left the ARC, did he contact you?
After the warrant was already issued for absconding.
Okay. When was the warrant issued?
It was issued. I don't have that date. I do have a date.
Okay.
It was, I have when it was served. I don't have when it was issued.
I'll get that in a minute.
It was, okay.
When was it served?
It was served on the 20th.
Okay. And when did he contact you?
He contacted me, like, I think it was like the day or so before he was picked up on it.
Okay. And what did you tell you?
He said that he had a foot issue and that he had served so much time or whatever, and then he was going to report to his officer in another county to where he was actually living. And then that ended up not happening.
What did you ask him to do?
To report to me.
And did he do that?
No, he was picked up on the 20th and he never made it to me.
Okay. Yeah. I don't have any other questions.
You have any questions, Counselor?
Yes. So you said that he was picked up on the 20th. Do you remember what day he called you?
I don't off recollection exactly what day that was.
But he said that he intended to report to you.
He did say that he intended to, but he never did.
What length of time do you think it was between the time you talked to him when he was picked up? A week?
A day or so, Your Honor. It was very short.
Go ahead.
Do you know how long he was in rehab before this?
I don't know the exact length. It says on this exit letter, the dates that he enrolled. 5/13/25 is when he first entered. As far as timeline, I'd have to use a calendar.
That's all the questions I have.
Okay.
No other question. I'd just like to ask Ms. Mile on what day the warrant was issued, probation violation.
9/16/25.
Okay.
You're starting on 9.
Okay.
Do you have any other witnesses?
I do not.
You want to call a witness?
Yes, Your Honor, I'll call Mr. Berg.
Will you raise your right hand, sir? Hurst. Mr. Hurst, will you raise your right hand?
Oh, yes, sir.
For the testimony that you're about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
Okay, proceed with questioning.
Mr. Hurst, how long were you at the Crown Rehabilitation Center?
130 plus days.
And how long were you supposed to be there?
For 6 months.
And now, what was the reason that you left the facility?
I had broken my foot back in August, about August the 10th or 12th. And due to my leg was swelling really bad because they think I have a heart condition. They already looked for a blood clot and couldn't find one. So I reached out to several different people there at ARC trying to get an appointment to see what was wrong with my foot because my foot was hurting real bad. So they finally got me into the hospital on August the 21st, I believe, if I'm not mistaken. And they x-rayed it and done a semi-ultrasound and put me back on to come back the 22nd. So I went back the 22nd of August and they decided that my foot was broke, seeing that my foot was broke. So they sent, and the way it works there is they send a letter back to ARC saying, I see my provider at ARC. So I seen him on the 24th or 26th, I can't remember which. And he put in an order for me to see a cardiologist and an orthopedic surgeon. Well, from then all the way up until September I'm thinking the 15th, 16th, somewhere along there, I never seen anyone. And I went to a comp where you talk to your clinician, and I told her that my issue, and she got on there and she looked at my medical records, and I was supposed to see a cardiologist back in July, and I never got any appointments. And my issue was getting worse. My leg was getting bigger and bigger and bigger. So ultimately, she got on her computer with her boss and emailed someone. And when I left my comp, I seen one of my directors, and he said, I don't know who the heck you've been talking to at the courts or who you talked to, but they're evaluating your whole my whole thing at ARC and through the courts and all this. And I was only allowed to certain areas on the campus. And I said, all I'm trying to do is get off this foot because it's a big campus. I got to walk up 56 steps just to get to a class. And I was doing everything. And then ultimately, I was contacting you as well, sir, a week or two before this, trying to get this done through the courts to where I didn't have to, leave that place. And that's basically all I can tell you. I wasn't trying to leave. I was just trying to get my foot fixed, and it is broke bad. I still don't have it fixed.
And Mr. Hurst, we were waiting on medical records. Is that correct?
Yes, I've got medical records I gave you yesterday, as well as I've got some from ARC. It reflects, I was supposed to get me to see a cardiologist back in July.
Any more questions?
No more questions, Ron.
Just a few. Mr. Hurst, did you report to a probation officer? Where were you at ARC? What town?
I was in Springfield, Kentucky. It's on Bardstown Road.
Okay, that's where I was getting the Bardstown, I guess. Did you have a probation officer over there while you was at ARC?
I only had I never seen a probation officer the whole time I was there, except for the last week that I was there, and that lady was out of Campbellsville.
Okay. When you left ARC on 9/11 of 25, where did you go?
I went home.
Where is your home?
Harrodsburg, Kentucky.
Harrodsburg. Okay.
Yes, sir.
And you knew that you'd had contact with Officer Garner before, that he'd been supervising, didn't you?
Yes, sir. But he had passed his case from me to another lady out of Campbellsville.
I know you got an excuse, but just answer my question. Where's his office located?
Adair County.
Columbia. You've been to that office, haven't you?
Yes, sir.
You knew Officer Garner's phone number, didn't you?
Yes, sir.
So you could have called him 9/11 when you left, couldn't you?
It was like 8 o'clock at night, sir.
Yeah, and well, you could call him the next day or the day after. And you know, you've had that absconding on here before on the violation report. You knew that, hadn't you?
Yes, sir, I guess.
Didn't it occur to you that it might look like you absconded again when you left rehab and then called your probation officer?
They told me at rehab that they was going to contact them, that they would be contacting me because I didn't know who to call, whether I called the lady in Campbellsville or Mr. Garner. I'm sorry. I did contact Mr. Garner. I'm sorry, sir.
What day do you remember?
It was on a Monday. The day I left on a Thursday, I contacted him on a Monday because I was on my way to ARC Anywhere in Lexington to get set up for OP on the street. I was in the last phase of ARC.
Well, according to my calendar, September 11th was on Thursday, and you may have called him the 15th. The warrant was issued the 16th. Is that right? So I'm kind of doubting that you would have called Officer Garner on the 15th and he'll issue the warrant the next day.
The day I talked to Officer Garner, he said, look, I'm not gonna get you for absconding. We'll see how the week plays out. Come in here Monday and see me. That's what he said, because the lady had transferred from Campbellsville to him.
And then you were picked up the 20th.
Yes,
That
sir.
right?
That was the weekend prior to the Monday I was supposed to go see him.
Okay, I have nothing further.
No questions, Your Honor.
Okay, you have another witness.
No, Your Honor.
You have any rebuttal witnesses, Mr. Stockton?
No, I don't.
Okay, you want to make your argument? Mr.
Yeah.
Stockton?
The only thing I would say, Your Honor, is just, it's clear that he has a medical issue. He was worried about it. He attempted to get medical records to try to do it the correct way.
Do you have any medical records to present for you?
There are some medical records that I gave to Mr. Stockton earlier today.
I agree that Mr. Hurst probably has medical records, and he's been given every break in the world. He's had violations starting 10, 28, 22, including absconding.
How much has he got on the shelf?
He's got 5 years on the shelf, and we've dealt with him, it seems like, for 10 years, Judge, just to be honest with you. And he may be telling partially the truth this time, but, he could have
How many
reported
days does he have in? It looks like to me it'd be parole eligible pretty soon.
pretty soon, I would say. I don't have the exact count. Officer Garner might be able to check. So
I'm more of a vote. I think it's not, his arguments aren't really plausible about doubting that he didn't have some medical problems, but he made no effort to comply. I'm going to revoke him, his probation. And I think the best thing for him to do is parole and get out from under this court here in the supervision. He doesn't fit well in the supervision model we have. Okay, well, thank you, Mr. Hurst. Thank you very much.
So how many days do I got in?
They'll come up and go over that with you here pretty soon. See how many good days you got. Make sure you get credit for all of them. Angel King every day. Morning.
Morning, Your Honor.
Are you Angel Kington?
Yes, Your Honor.
Yeah. What's your year of birth?
10/04/1996,
Last 4 digits of social security number.
5901.
You're here for sentencing. Have you had an opportunity to look at the probation, the pre-sentence investigation report done by probation parole?
Yes, he did.
Is there any reason this lady should not be sentenced?
No, Your Honor.
Upon pleading guilty, possession of controlled substance first degree, the defendant shall receive a sentence of 3 years probation and 5 years to be supervised. Shall be referred to the social commission and follow any and all other defendants shall receive credit for time served. Obtain gainful employment, do 30 hours per week community service. What's the court cost?
$275.
$275. You need some time to pay that?
Yes, Your Honor.
Your first $40 within 30 days and $40 every month, and that's paid in full. She can be released. When can you see her?
I can see you as early as tomorrow, Your Honor.
Yeah, I'm gonna release you in the morning at 8 o'clock, and you just go on over to the probation and parole office from there, and then have somebody pick you up, okay?
Okay, thank you.
Very much. Jennifer Robinson,
Your Honor, she stepped out. She had used the restroom.
Butch Sally. Butch Sully. Are you Butch Sully?
Yes, sir, I am.
Okay, good morning. This is
Good morning, sir.
25 CR 0047. Mr. Sully, were you born in 1972?
Yes, sir.
Last 4 digits, social security number 7397.
Yes, sir.
For the purpose of arraignment, you have a right to remain silent. Public advocate. District Court, I'll continue that appointment. The grand jury of Cumberland County is returning indictment charging you possession of first degree methamphetamine and possession of drug paraphernalia. Count, Mr. Bailiff. Sir. Counselor, you acknowledge the identity of your client, receipt of indictment, waive formal reading, arraignment, enter plea of not guilty, preserving all pretrial motions.
Yes, Your Honor.
Set for a a negotiation day on the 17th, and the next court date will be on the 23rd. Your attorney will be up to talk to you about this. Setting a reciprocal discovery order requires the Commonwealth to give you the information they have so you can prepare for your defense. What's the charge he has in
Possession.
What's his bond?
4,000 shares.
25,000. Have you been able to make your bond, Mr. Salih?
Oh, sir, they ROR'd me when I first came in here because I was released to another state.
Yes.
And it's just been a constant. I figured it up here since then. And I was brought back up here on failure to appear on this charge. And they made it.
Got it. Okay. I'll make sure that you have this thing on this, you have this negotiation on the 17th. And we'll try to, if we can't get this wrapped up on the 23rd, we'll set you a speedy trial day, okay? Try to advance it for you. Now, where do you live, Mr. Salih?
In Lafayette, Tennessee, sir.
Lafayette. And do you have charges down there?
No, yes, sir. Yes, sir. It's they said they were going to be for time served for this last time, but I still got to go back to court.
Yeah. Okay. Well, your attorney will be up and go over it with you. Okay.
Yes, sir.
Thank you very much. Bernice Stern. Bernice Stearns. Are you Bernice Stearns?
Yes, sir. Good morning, Your Honor.
Good morning. This is 19 CR 00106. Ms. Stearns, you born in 1982. Last four digits, social security number 0513.
Yes, sir.
We're here on a shock probation revocation. What does the Commonwealth have to say?
Your Honor, she has a 3-year sentence on possession. She had some positive tests. I talked to Officer Garner about maybe putting her in the specialty court, and he said he could have her assessed and send her to long-term treatment. And I think he's already got that right.
I do, Your Honor. I've already got a bed waiting on her, but we were just waiting to get this official, the fourth one stuff.
We submitted an agreed order on this one.
Yeah, we did. I forgot.
To revoke the shock probation.
In lieu of revocation.
In lieu of revocation. Okay, let's, before we put her in specialty court, let's see how she does in the treatment thing.
Yeah, we're going to send her there in lieu of specialty.
In lieu of that, okay. Okay, we'll send you to a rehab. They'll be up to talk to you about it pretty soon, okay? Thank you very much.
Okay.
Work hard on it, okay?
I will. Thank you, sir.
Silas Taylor. Commonwealth versus Silas Tabor. 25 CR 0054. Are you Silas Tabor?
Yes.
Good morning.
Good morning.
Were you born in 1976?
Yes.
Last four digits of social security number 6042.
Yes.
Okay, we're here for pretrial conference. What does the Commonwealth have to say?
So, Your Honor, in Mr. Tabor's case, he was also charged in Monroe County, but it looks like from the officer's review of the case that he may have been incorrectly charged here, but the Commonwealth wanted to verify via the DCBS record. So, and they have to get a court order for those, and they're going to do that in the Monroe County case. So
Tell
once
me what you want to do.
Let's just pass it a month, and we should probably enter an order of dismissal here in Cumberland County. We just have to get the DCBS records and review those.
To verify.
Okay, October 23rd, unless I receive an agreed order on this case here before then, okay?
Thank you, Your Honor. And that's all I have for today.
Yeah, have a great day.
Goodbye.
Sean Wadley. Commonwealth versus Sean Wadley, 24 CR 0031. Are you Sean Wadley?
Yes, sir.
Born in 1972.
Yes, sir.
Last four digits, social security number 9513.
Yes, sir.
We're here on a pretrial diversion revocation. What's the Commonwealth have to say? I have no. What does the Commonwealth have to say?
Your Honor, this is our motion to revoke pretrial diversion. He has a possession charge in Georgia. I think he may have two. He's tested positive down there. Officer Garner would have to resubmit this if we do anything in lieu of revocation to Georgia to see if they would take him back. And he served 90 days up here I'm willing to do a sanction up here on this and send him back to Georgia. Just, then let them deal with it where I'm at. But that's my proposal. The order in lieu of revocation, make him unsupervised as long as he resides outside the Commonwealth of Kentucky, and let him have his day of court in Georgia.
We're agreeable to that.
I would assume you would be.
He has 90 days in.
So,
Well, how do you know the sanction's gonna be 90 days? I didn't hear that portion of it.
That's what he just.
well, I'm agreeable that if the court wants, whatever the court wants to do, or if you want us to proceed with the hearing, we'll do that. But that's what,
How many days would you suggest, Mr. Bell?
I suggest 30, Judge. He
He's
done
already
great time.
surpassed that.
That's what I'm saying.
Okay, well, I'll make it a 90-day sanction. So is there a hold on him in Georgia?
I don't think they've got a holder on him. They got pending cases on him down there.
Well, do you think they ought to be notified before we release
I
it?
think they should. He needs to call and make arrangements to report down there.
Okay, well, I'll just tell you, we'll withhold releasing him, let's say for 48 hours or something like that, so that they can notify Georgia to see what they want to do. If they want to come pick him up or give him the date or whatever. Does that sound fair?
Anyway, we let him out tomorrow, Judge, for 48 hours would actually be probably 4 days. But he ain't gonna get out on the weekend.
I know I got court date October 6th down there.
October the 6th, that'd be me.
Let him out today.
That's fine. with me.
Thank you, Judge. Be on your way rejoicing. We hope we don't see you up here anymore unless it's a fishing trip after you get all this behind you.
I hope I stay home.
That'd be a good thing for you. Okay, thank you.
Thank you, Judge.
Thank you.
Jennifer, I guess the last case is Jennifer Robinson, is that right?
Yes.
Jennifer Robinson. Okay, this Jennifer Robinson, this is 24 CR 0041. Were you born in 1986?
Yes, sir, Your Honor.
4-digit social security number 0286.
Yes, sir, Your Honor.
What does the Commonwealth have in this case? Probation revocation.
There it is. Miss Robinson has a 10-year sentence. She first had the 2-year sentence on possession. She pled guilty to that, served out. Then she pled on the 10-year burglary first, where she stole a firearm. And basically, when she was released in June, she never reported to Officer Garner, and he's never been able to supervise her. So I'm at the Commonwealth's requesting that this 10-year sentence be imposed.
Your Honor, whenever she had,
You want to stipulate?
yes, we'll say
Stipulate. Okay, now let me hear your argument as to why.
Yeah, Your Honor, whenever we came up with the agreement, she was supposed to go into rehab. However, new charges started coming up in different counties. And so it took a little longer than I think any of us expected. When she finally was released, I believe Ms. Robinson told me she was unsure of who to report to or what to do to get into the rehab facility.
She called you about it?
She did not call me.
I called the treatment facilities, a few of them myself to try to get in. And a lot of them won't accept my health issues that I have. A lot of them say that they don't have a doctor on site that can handle health.
We need to about the efforts he made to locate her, checking justice chains and all that.
Yeah.
She's just not one spot.
I was at one spot the whole time.
They've stipulated to the violation, so I'm gonna go ahead and revoke the pretrial diversion. Revoke the probation, and she can get her good time, make sure she gets all her good time that she has in there, okay? Thank you very much. Is there anybody else up there at the Adair County Jail?
What does that mean?
No, Your Honor, that should be everybody that you have on the docket.
Yeah, I appreciate the good job y'all do, but I would suggest you have somebody in the room to help you handle this. Man, we're
Yes,
finished.
sir.
We're finished with you. Thank you very much.
Thank you.
No, I'm talking about the prisoner there, okay? You can go on back to the cell. I revoke your probation, okay? Now, this guy was out of hand, and y'all need to have somebody in there available, because I'm not.
Your Honor, I normally do have another person with us. We just happen to be very short-staffed today.
Well, if you need my jailer to come up there and help you, he will.
I appreciate it.
Thomas J. come up there and hard arm him for me.
Thank you, Your Honor.
Y'all are excused. Thank you very much. I guess that finishes the criminal docket for the morning. We're waiting for the grand jury, so let's go off the record.
Yes.
Okay, show cause. Well, let's go ahead and do the show cause docket. Jamie Scott, Commonwealth versus Jamie Scott.
She made payments.
$5.
She made $5 payments. All right, thank you. Just want to make sure I got it. You said after the fact that he was accepting it, so I wasn't right.
Okay. Sorry, I'll lead with that.
All right, thank you. All right. Sir, it's my understanding that you're going to be pleading to an addict.
Attorneys or anyone not on the jury. 2, you must not discuss the cases unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the cases until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must tell the judge if anyone attempts to contact you about the cases before you is. Good morning. Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. So at this time, ladies and gentlemen, I am required to read the entire court's charge to you. So here we go. Cause numbers 24 DCCR 0917 and 24 DCCR 0918, the state of Texas versus Dalton Batiste. Jury instructions. Members of the jury, the defendant, Dalton Batiste, stands charged by indictment in each case with the offense of murder. The defendant has pleaded not guilty, and you have heard all the evidence in each case. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty in each case. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable in this case. General principles. The indictments are not evidence of guilt. The indictments are documents required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charges. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. You may find the defendant guilty only after a careful and impartial consideration of all of the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state
participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, all of that can be provided to you at no cost. If you cannot afford an attorney, I'll appoint one for you at no cost. Is you're eligible to, although I doubt that I would consider it because it's an agreed sentence on a modified, an agreed reduction of the charge from an F2 to an F3. Right. So it took you out of reg and togs with an agreed sentence of 18 months. Usually, and I will just tell you this, it doesn't make you ineligible to ask for it. But when you get into this 18 months, it's, again, I'm not going to say never, but usually on an agreed sentence, I will tell you that my philosophy is if you've agreed and gotten the benefit of the bargain at this stage of the proceeding, I don't let you change the terms down the road. Does that make sense?
I understand.
Okay, so that's my philosophy. I'm not going to sit here and tell you, absolutely not. You are eligible to file for it when this time starts, but I don't know that I would grant it. Is that fair?
Yes, sir.
Okay. Anything else, sir? All right. Good luck to you.
Thank you, Judge.
Good luck. We done?
Yeah, you're done.
I thought we didn't bring Red Key in for.